That item number 14 may be taken up for stay application, and item number 162, 64, 65, 66, they are for absolute kind.
But I am for the respondent number 53, Union of India, madam. So this matter is fixed on 29th of August to 25, my lord. I don't know why it has appeared into the.
There must be some correction.
Correction in the case number, my lord. WP, it has wrongly got down to 11, my lord. It should be 2001, my lord.
Yes. Let the matter. It will appear on the returnability.
My lord, my lord.
Number 227, will ask for the petitioner. This writ petitions were taken up by your lordship on
Okay, correction.
20th November 2024.
So they had misplaced the file. Yesterday, somehow they pasted it out. So that's why I had asked them to list under the heading to be mentioned. So I believe this order could not have been communicated.
My lord, this order, my lord, your lordship directed the registrar.
Yes,
My lord,
that is why they had misplaced the file,
Oh.
and therefore this order could not be communicated. Okay. The learned advocate representing the petitioners. So you are representing all the petitioners in all the writ petitions. It's present and appear to represent the respondent state. The department informed to have misplaced the case record, and accordingly the order dated 20th of November 2024 could not be complied with. Next date be fixed on 8th of September for further hearing. In the meantime, the order dated 28th November 2024 is to be complied with forthwith.
I'm grateful, my lord. Extremely grateful.
None appear to represent either of the parties. Let the matter be adjourned for the day. Yes, your friends will be coming. No.
Yes, she has come, my lord. Kindly
No,
pass it over.
Omicron Roy.
No. I'm listening. No. I haven't seen him, my lord.
Same order.
I appear for the appellant.
My lord, I beg to appear for the respondent.
In this matter, the first order was passed, my lord, on 13/2/2024. When the appellant was directed to serve two can, one is for condonation of delay and another for stay of the the impugned order. Then both the can was duly served by register post, and then a affidavit service was filed. Thereafter, matter was on that day, the delay was condoned and the appeal was regularized, it was registered. And then thereafter, can was allowed and can 2 was fixed for another day for hearing. Can 2 is the stay application, Then can 2, that is the order dated 16/4/2024. Here, kindly have a look, that can 1, regarding can 1, order has been passed, and then can 2 is the at page 3,
Did you serve notice?
I have served the notice. May I leave to file affidavit of service?
When did you serve?
You know, that is served, my lord.
Whom are you appearing for?
My lord, I'm appearing for the respondent. My lord, we have served them twice
11th of
regarding
July
the last
2024.
order of
You don't have it.
Justice Samantha for compliance, and they haven't served us, Your Lordship.
What were you supposed to serve them? The copy of the memo of appeal?
I have, my lord, now, today, a matter has been fixed. Can 2. Can 2 is the stay application. So, my lord, your lordship will dispose of today the can 2, that is stay. My lord, that is the order, impugned order that passed in 2016. My lord, this is the appeal from the Railway Claims Tribunal. And my lord, the award, my lord, the case was,
What is the amount of compensation?
that is very small amount, my lord, that is 50,000 rupees only.
So have you deposited that?
My lord, here it has not been deposited. I preferred
First
an appeal.
deposit and then come.
No, it has been, appeal has been preferred, my lord, here. I have
Yes.
preferred an appeal, my lord. And
That is what I'm saying. I'm asking you to deposit the amount and then come.
my lord, instead of that, my lord, with that I have prayed for stay, my lord, and there is a legal
Sir,
issue involved.
you've deposit the amount and then come. The learned advocate representing the Appellant Union of India is to deposit the compensation awarded by the Railways Claims Tribunal at the office of the Registrar General High Court at Calcutta prior to the next date of hearing. I'll give you time to do that since you are representing the
Union of
uh,
Railway.
railways. Next date be fixed on 19th of September.
As your lordship.
Obliged, my lord.
Yesterday you said you were threatened.
Lord, I was threatened, but my lord, I didn't talk to any one of those who threatened me. My lord, I spoke to Mr. HON'BLE. He said if we can dispose of even one appeal today, my lord, so I came. Well, they are not aware that I have come today. Those who have threatened me.
In any case, they will be aware.
My lord, this is the insurance appeal appearing for the first time. Lord, as there is no condonation in this case, I was praying for interim stay. my lord.
Dehi rekotte. The report of the stamped reporter stated the appeal to have been filed within time and in proper form. Let the same be admitted. You've given the copy of the challan?
Yes, my lord. Yes.
4 weeks, issue notice, serve affidavit of, file affidavit
My
of
lord.
service. 25th of September.
25th September. Extremely grateful to your lordship. my lord. Lord, item 12, my lord, is also a similar application on behalf of insurance company. In this case, also
Is there any delay?
there is no delay, my lord.
Same
for
order.
interim stay.
25th September.
Extremely grateful to your lordship. my lord.
In this matter, I'm appearing on behalf of the appellant. There is no delay, my lord, and I have paid the statutory deposit 25,000. Pressing for the stay application, my lord.
Get the balance amount deposited
Yes.
within 4 weeks. Serve notice and then file affidavit of service. Next date, 24th of September.
Great.
Next. 24th.
No,
Yeah.
my lord, only
Same order. 24th of September. 4 weeks, issue notice, file affidavit of service.
Yesterday, Milord, I was pressing the BSF rules governing, my lord, the proceedings against a charged officer against whom an allegation is made. Now, my lord, may I briefly indicate, my lord, what will be the subject matter of my address before the lordship? My lord, the question is, my lord, lordship will be examining the only decision-making process, not the merit of the decision, but as the writ court may, decision-making process. Now, the decision-making process obviously will be in the background of the rules and the act governing, my lord, the conduct of BSF personnel and, my lord, their disciplinary proceedings. Now, if your lordship finds that there is an infraction from the rule in the process of holding me guilty, because, my lord, lordship has seen, my lord, that ultimate punishment was dismissal from service and 6 months imprisonment in BSF custody. So, I suffered the maximum consequence. Except for death, my lord, that's the consequence of maximum for me. So therefore, lordship,
You underwent that period of custody?
yes, I underwent the period of custody in BSF custody. Then what has happened, unfortunately, when even then after that I was not released. Even after the expiry of 6 months, I was not released. That's on record. So I had to file a writ petition before this honorable court, perhaps in the nature of habeas corpus, my lord, seeking my release, and the honorable court was at once, my lord, pleased to order my release. That's how I was released from BSF custody. Milord, my argument will be on the question of victimization. It will see, Milord, Supreme Court has defined what is victimization in departmental proceedings, how victimization is to be construed, Milord. We shall place case laws on that. We'll come to that. And the question is, Milord, these provisions having smacking of disciplinary inquiry and, Milord, leading to punishment should be strictly construed. Penal provisions, there is no question of relaxation. So I'll place case laws on that also. And ultimately, my lordship will kindly see the question of punishment. If your lordship comes to the finding ultimately that the punishment is disproportionate, because the Supreme Court has said that if the court comes to the conclusion that the punishment is disproportionate, then obviously that leads to the inference of victimization of the employee. The victimization is not permissible. An employee is entitled to fair treatment in the hands of the employer. In that case, the court is not powerless to interfere, even in the writ proceedings, with the punishment imposed on an employee. Now, my lord, as I was placing before lordship, my lord, the rules. Hey, I'm not going to. Lordship has got a copy of the rules, my lord. Now, I was placing.
Lastly, we were on 51 capital A.
Yes, 51 capital A. Lordship, blessed you, lordship. So, before that, my lord, once more, my lord, may I place rule 45B. That is, my lord, my superior officer, who is the commandant, 45B1A. The charge against an officer or a subordinate officer shall be heard by his commandant. So I was under the commandant. I was just an assistant, assistant commandant. No? I was a junior officer under the commandant was the head of the unit. So he used to head the charge. Then, my lord, lordship kindly comes straight away to, my lord, C, 45BC. Assistant commandant. My designation is assistant commandant. I was under the commandant. First of all, 45B1A, the charge against an officer, subordinate officer, shall be heard by the commandant. This word shall should be construed as mandatory. Shall be heard, because this smacks of a penal consequence. Shall. No question of relaxation. Shall be heard. Then, my lord, 45B D, my lord, 1D.
Yes.
Before that, C, my lord, wherever witnesses are called by the officer hearing the charge, the accused shall be given an opportunity to cross-examine them. So it's not an ardent formality. Here is a my lord, opportunity of cross-examining. Then, my lord, for ascertaining the facts. Then D, Thereafter, the accused shall be given an opportunity to make a statement in his defense. Almost, my lord, in nature of regular, my lord, proceedings. Then, sub-rule 2 is very important. After hearing the charge under sub-rule 1, the officer who heard the charge may dismiss the charge or remand the accused for preparation of a record of evidence. Your Lordship will kindly remember the incident took place on 10th of September. And on 11th of September, my lord, the commandant ordered record of evidence. So, where is this intermediate compliance with Rule 45B? This can be skipped at his sweet will. So, my lord, here is the question of production of the records by the department before your lordship to satisfy your lordship that 45B was also complied with in course of 24 hours, where cross-examination, opportunity of defense, then consideration, application of mind, because it said after hearing the charge means what? After hearing the charge means application of mind, not a mechanical milord appraisal, but after hearing means he has got to apply his mind to the charge and milord the evidence, milord whatever comes in his way. Then after this is done, he may dismiss the charge. So this is very material. The accused may be exonerated at that stage or remand the accused. So this is 45B, my lord. We are at a loss to understand how this could be, my lord, completed from 10 September to 11 September, because on page 16 of Sakya Dikheza, Lordship can see in 11 September, he is ordering recording of evidence. Page 16, my lord. My lord, last line in page 16.
Yes, I have marked it.
ROE means record of evidence proceeding duly completed in all respects submitted and signed by 18th September 2007 for taking further necessary action. A.K. Jadhav, Commandant, 11th September. So this record of evidence is ordering record of evidence process is vitiated. Then, my lord, in record of evidence, there is also, my lord, further scope of examination of witnesses. I can cross-examine. Here, Lordship Miller has seen, my lord, I was still under mental infirmity, so to say. Not fully, my lord, cured. Undergoing a process of convalescence, under medication. And the doctor has said, my lord, that in short, my lord, I was passing through an abnormal phase of mind. Depression effect is still continuing. So therefore, and the doctor has advised that not
7 days rest.
7 days complete rest. But that is not allowed. In hot haste, my lord, the record of evidence that the trial took place after several months. Heaven shouldn't have fallen if they had waited for a few more days. Be that as it may, my lord, then the trial proceeded. Now, Lordship kindly says, my lord, the next page, after the record of evidence was over, 61, he thought that this case should be tried by the General Security Force Court. Lordship allows me to place this document. The details of officers as mentioned below will assemble at SHQ, BSF, Shiliguri, etc. 15th of January for the purpose of trying by General Security Force Court the accused person named in the margin. Then, my lord, the names of the members are given, 5 members. This is a 5-member full bench. General Security Force Court. Now, what is General Security Force Court? Lordship kindly turns to, my lord, section 64. Section 64 of the Act. Kinds of security force courts. For the purpose of this Act, there shall be 3 kinds of security force courts, that is to say, General Security Force Court is the highest in the Aquilan Miller, Petty Security Force Courts and Summary Security Force Courts. Prior sent for trial before the General Security Force Court. and generally security force court, my lord, consisting of 5 members. There are 5 members of general security force court. And all the 5 members, my lord, heard my case. 9 January 2008. It was constituted on 9 January 2008. And in course of the generally security force court proceedings, my lord, the prosecution examined 15 witnesses and I examined 5 witnesses. And the prosecution witness, my lord, I have shown to your lordship, my lord, just my lord, refreshing our memory, my lord. One of the prosecution witness, Rajesh Kumar, in whose bungalow, my lord, I fired. Allegation I fired in his bungalow with an intention to, my lord, hurt him, section 307 of the IPC. But I was exonerated from the charge. Be that as it may, my lord, Rajesh Kumar has come and deposed that a patient suffering from this type of disease, my lord, the accompanying guards should also not carry arms. Lordship kindly briefly looks at that, my lord, at page, my lord, what is evidence. At page, my lord, 174, once, my lord. This is not my evidence, evidence of the prosecution witness, 174. Is referring to the guidelines, 174, last line. 174, Lordship got it.
Yes.
This is cross-examination of PW13. His name is Rajesh Kumar by the defense. In course of cross-examination, he has said, as per para 7 of guidelines policies issued by Medical Directorate Bhide L number 1620, etc., June 2003, meant for psychiatric examination, diagnosis, treatment, and disposal of service personnel and their families suffering from psychiatric disorder following to be adhered. Lordship kindly straight away comes to C, ABC, guards and escorts of psychiatric patients. Guards and escorts of psychiatric patients should not carry arms and ammunition unless the individual is a disciplinary case under close arrest. In such cases, the armed guards should not be in proximity to the patient. Pausing it for a moment, my lord, I was not a disciplinary case till then. Disciplinary case means against whom disciplinary proceedings is pending. So armed guard should be there, my lord, to prevent his escape from custody. So as not a disciplinary case, even in case of disciplinary case under close arrest, in such cases, the armed guard should not be in proximity to the patient. Even in the latter case, the armed guards, the guard carrying arms, he shouldn't be in proximity. And in my case, he should not carry any arms at all. But what has happened, my lord? This gentleman who was my escort, my lord, I have shown to your lordship, but Govindra Singh Bhala, he was armed to the teeth. He was issued with an insas rifle, which is used against the, my lord, extremists, Jungis in Kashmir, recently Pahalgam, my lord, they came with AK-47, that is the insas rifle. So he was issued an insas rifle and 20 rounds of cartridge. So the preliminary lapse is on the part of the authorities concerned. This will lordship will kindly not lose sight of. Chala's evidence, lordship comes to 131, my lord. This is my escort. ঠিক আছে. Page 131, lordship looks at. What is he saying? First witness for the prosecution, page 131. Only for the purpose of this arming ammunition. My lord, the last paragraph. 131, 131. He was my armed escort. First witness for the prosecution, Constable. Has the lordship got it, Miller?
Yes, I was
Constable.
issued with insert rifle, butt number such and such, body number such and such, along with 3 magazine filled with 20 rounds each.
That means 60 rounds each. In state committee itself. So this is the position. Now, yes. Now, my lord, coming back to this, my lord, the trial, my lord, the trial proceeded. 15 witness prosecution, 5 witnesses for me, all doctors. Some of them were, my lord, specialists. My lord, I am not, my lord, repeating their evidence, my lordship, when necessary, I shall refer to it later on, at later stage. Dr. S.K. Das, my lord, who examined me on 10 September beforehand and who detected me from MDD, said that it can relapse at any moment. And, my lord, he is recounting, my lord, he is recording in his prescription what I told him regarding the taunting of my senior officers. And he says that such type of patient can suffer from delusion, as if, my lord, I was in fear of life, as if, my lord, my life was under threat. This delusion, my lord, led me to some abnormal act. The doctor said that I was suffering from delusion, my lord. Not only Dr. S.K. Das, thereafter, my lord, Dr. Behera, who examined me, my lord, on 12th of September, he also said that, my lord, I was suffering from delusion. So these two are the evidence in my favor. I mean to say regarding my mental condition, abnormal. Now, my lord, lordship knows, my lord, very often, my lord, these members of this, my lord, armed forces, especially BSF, my lord, we very often read in the newspapers, my lord, they suffer from deep depression. And also army people, also those who are placed in remote areas, my lord, this is their professional hazard they undergo. So they should be treated with tenderness and due care by the authorities, not like a common criminal. Be that as it may, my lord. Now the provisions which are mandatory for the General Security Force Court members to follow. My lord, after the trial is over, what they should do? Lordship kindly comes to me, Lord. Section 86. Why I say so, my lord? Because I'll call upon the, my lord, the learned counsel for the BSF to satisfy lordship on this point. Voting by members, subject to provisions of subsection 2 and 3, every decision of a security force court shall be passed by an absolute majority of votes, and where there is an equality of votes on either the finding or the sentence, the decision shall be in favor of the accused. No sentence of death, I'm not coming, this is not relevant. In matters other than a challenge or a finding of sentence, the presiding officer shall have a casting vote. No question of that. The question is voting by members. So they will have to produce the records before lordship, the records that we have been given, my lord. They say this is the correct records, my lord. We have scanned these records, my lord. There is no indication of how they have complied with section 86. 5 members, there was a possibility of dissent, must be 3:2 or 4:1. Nobody knows. So records must speak for itself. This is a quasi-judicial trial. The records are very material. Then, my lord, lordship kindly turns to.
Yes, sir.
Lordship kindly turns to, my lord. The next rule in this.
Shugata.
Rule 98. Voting by members, then Rule 98 of the rules, my lord. Deliberation and finding, Rule 98. Another case of production of records, Rule 98. The court shall deliberate. My lord, this is, my lord, the heading is, heading of the section is, heading to the keys of Judge Sahib ke. Milord, heading of the section is Procedure for Security Force Courts. Chapter 9. Procedure for Security Force Courts. Then, Milord, 98. Deliberation and finding. The court shall deliberate on its finding in closed court in presence of the law officer. In presence of the law officer, he is one of the member of the prosecution, but in his presence, the court should deliberate. The opinion of each member of the court as to the finding shall be given by word of mouth on each charge separately, starting with the junior most in rank. So, Milord, here is also a question of production of record as to how they have complied with this Rule 98. What is the deliberation among the members? Who expressed their view in favor, who expressed view against me because I was exonerated from one charge and held guilty in another charge. So the charge about which I was held guilty, what are the views of the members? What is the voting among the members? What is the deliberation? Each member should express his view orally, but there should be a record. Yes, orally, but somebody should record. Who will record? The chairman of the General Security Force Court, the first member. Record an announcement of finding, Lord. 99. The finding on every charge upon which the accused is arraigned shall be recorded, and except as provided in these rules, shall be recorded simply as finding of guilty or not guilty. After recording the finding on each charge, the court shall give brief reasons in support thereof. The court has given reasons, in my case, reasons in support thereof. The law officer, or if there is none, the presiding officer shall record or cause to be recorded such brief reasons in the proceedings. The above record shall be signed and dated by the presiding officer and the law officer, if any. So, record shall be signed and dated by the presiding officer and law officer. It is good as so far as it goes. Presiding officer and law officer, when a law officer is proved at par with the presiding officer, is a member of the prosecution, but be that as it may, Milord. Question is, Milord, it speaks of a record. So, record should reflect or contain the views of the members, the deliberation, starting from the junior member, what is your view, what do you say, finding guilty or not guilty. So, this is the mandatory provision, Milord. This cannot be, Milord, in any case, Milord, ignored or disregarded. So, finding of, they should produce the records, Milord. The records that they have given, we don't find any reflection of how they have complied with Rule 98. There's nothing, not a single line, Milord. I stand corrected, Milord, if my learned friend can produce the records to the contrary. Then, Milord, next rule is also, Milord, bearing on the topic, that is Rule 116, 116, 116. Every member of a court must give his opinion by word of mouth on every question which the court has to decide, and must give his opinion as to the sentence, notwithstanding that he has given his opinion in favor of acquittal. So, give his opinion. So, where is the record of the opinion? One has a right to see. The court has a right to see. So, entire record of the proceedings should show how they have complied with these mandatory provisions. And any deviation from this provision, any omission to observe any of the steps here, will vitiate the proceedings, will lead inevitably to the conclusion that justice, the failure of justice, the fundamental principles of judicial procedure were not observed. Deviation from fairness, fair treatment, and absolute impartiality. Then, Lord, the inference of victimization will naturally come in. Milord, Prosecution says, Rule 126, powers and duties of a law officer. I'm not going into that, but really speaking here, the law officer acts almost as a member of the team of prosecution. Law officer acts as a member of the team of prosecution. He is a law officer of BSF. He acts as a member of the team of prosecution. He doesn't act as my defense counsel, nor he is an amicus curiae. He is an independent person. But he has been given a part in the deliberation of the finding of guilty and not guilty, Milord, whatever, be that as it may, Milord. But the law officer here is very active in his role, I should say. Milord, Rule 127, only digressing for a minute. Milord, the BSF authorities are aware that their personnel may sometimes, Milord, suffer insanity. Their course of duty is such. Where the court finds either that the accused is, by reason of unsoundness of mind, is incapable of making his defense, or that he committed the act aligned but was by reason of unsoundness of mind incapable of knowing the nature of the act, or that it was wrong or contrary to law, the presiding officer, or in the case of summary security force court, the officer holding the trial shall affix his signature and the date on the finding, which also shall be signed by the law officer, and thereupon the proceeding shall at once be transmitted to the confirming authority. Or in the case of summary security, deputy to countersign the same. So they are taking note. The rules itself will not contain a provision for safeguard. Now, unsoundness, in Lordship yesterday was referring to what is unsoundness of mind. So insanity is equivalent to unsoundness. Unsoundness, Milord, the word means something which is not sound. That means, Milord, abnormal. That which is sound is normal. Whoever is unsound, Milord, may not be insane, but may be said to be abnormal. Now, abnormality may take different hues and colors. This suffering from deep depression, Milord, in my humble submission, leads to unsoundness of minds, especially with regard to, Milord, the observations of the doctor witnesses. কি বলছেন? Dr. Bharati Sen is saying, Milord, কি বলছেন তাকে? On 13th and 14th September, when the ROE was going on, there, Milord, the accused was depressed, slow speech, abnormal belief that someone will kill me. But this is delusion. Someone will kill me. Same thing, confused insomnia. On 15th also that continues. But this is the position. Now, Milord,
as per my opinion, the accused was not in a mental state at that time.
Milord, another doctor at page 193, Dr. Milinak Bishas, he is saying, I did my MBBS and MGM, Medical College, Jamshedpur, this thing, that thing, are joining STC. Milord, second paragraph. On 10th September 2007, between Satin Saji, heard sound of fire. I came out. Then next paragraph, Milord, as per my opinion, this is very material. This different doctor is saying the accused was not in proper mental stage at that time. I told the commandant that the accused was exacerbation of psychotic attack. Immediate treatment advice. He was under heavy arm. He is doctor of BSF.
193.
And there she is saying he was under heavy armed escort, even in my room. Then I told him that he is patient and not a criminal, and this type of activity can aggravate the disease of the. Milord, even in a doctor's chamber, Milord, they came under heavy armed escort. But this is the conduct of the BSF, Milord, personally. And the doctor said
This
that
was prior to the incident.
on the date of the incident, 10th September.
So after the incident.
Yes, after the incident. After on 19th September, accused was brought to 19th September, 9 days after the incident also. This is the position of the accused. And on that date, 10th September, she also saw the accused. In second paragraph, she is saying about 10 September, and the last paragraph she is speaking about 19 September and other dates also, some date in October also. So this is the position. Now, this General Security Force Code thereafter, as I have shown to your lordship, gave a finding of not guilty on section 307. 307 IPC. 307, as far as remember, attempt to murder. Lordship knows better, Milord. Lordship can look at the charge.
Sir, your mic is on.
Yes. Oh, I'm sorry. Milord, page 60, the charge, page 60, first charge, offense first charge, at about 14:30 hours on 10 September 2007, entered in government quarter of type 5 of Sri Rajesh Kumar and subsequently fired 3 rounds therefrom at Sri Rajesh Kumar with an intention to kill him. And this charge is attempt to murder, punishable under section 307 IPC. The attempt to murder charge as exonerated. They did not believe the evidence of Rajesh Kumar. The Rajesh Kumar is the same fellow who said that I produced before Lordship Milord that notification that should not be accompanied by armed guard. Then second charge, section 40. Second charge, an act prejudicial to good order and discipline of the force. Good order and discipline. At about 14:25 hours on 10 September 2007, unauthorizedly took Insas rifle but from Constable Gajendra Singh Jhala. Unauthorizedly took the rifle. This is the charge. Must be strictly construed, Milord. Simply it ends with that. Says that unauthorizedly took, says one stops. Taking unauthorizedly. Matter ends there. Section 40. Milord, thereby it was prejudicial to good order and discipline of the force. Nothing more, nothing less. Good order and discipline. And therefore,
Who was detailed as escort with gypsy number such and such.
yes, detailed escort gypsy number such and such. What happened, Milord? The Gajendra Singh Jhala left the gypsy to go and bring my civil dress from the mess, officer's mess. Then, Milord, that delusion, as this effective delusion, Milord, the impressive delusion, Milord. So I got down from the vehicle and then, Milord, went to the bungalow of, I must tell you, Lordship, what are the facts, Milord. Make a clean breast of the matter. Rajesh Kumar, who was my superior officer, and there fired 3 rounds in the air. After firing in the air, then I came back. I broke down in tears. I went to the temple. I broke down in tears. So I was arrested from the temple. I was immediately placed under suspension and also I was taken into custody of the BSF. House arrest. Or no, BSF prison. I was taken into custody. Then the trial, then Milord, the ROE and the trial continued thereafter. And it continued at the end, Milord, was dismissed. Now, be that as it may, Milord, the finding of the General Security Force Court, Milord, the finding was first charge free, not guilty, second charge guilty. Now, this finding did not find favor with the higher authorities. Perhaps they found that on the first charge also I should have been found guilty. So what they did under the BSF Act and Rules, Milord, they sent the matter back for reconsideration to the General Security Force Court for reconsideration. On reconsideration also, they returned the same finding. Milord, I don't think I need once more draw lots of attention to the details, except that, Milord, the order 203. This is the reconsideration. I mean, review 203. The court is closed for reconsideration of finding on the first charge. On the first charge, naturally held not guilty, that was sent for reconsideration. Held guilty is all right, that is accepted by the authorities. Held not guilty, reconsider. Finding, having reconsidered all the matters raised in the revision order, the court respectfully adhered to its former finding of first charge announced on 18 February 2008. This was on 31st March 2008. On review also, they stuck to the earlier view. And this finding on first charge is read in the open court and announced as being subject to confirmation under section 107. Now, Millard, pausing here for a moment. Lordship, can turn to section 107. Section 107.
Yes.
107 says, finding and sentence not valid unless confirmed. No finding or sentence of a general security force court or a petty security force court shall be valid except so far as it may be confirmed as provided by this act. Power to confirm finding sentence general force court by the higher authority. Power to confirm is by the higher authority. Now, page 203 speaks for itself, Millard, how it is confirmed. Lots of can listen.
Then withhold confirmation and transmit the proceedings to the DGBSF.
Yes. IG withheld confirmation, transmitted it to yet higher officer. Director General, he is the highest in the rank. Above him, there is none in BSF. Now, page 204, the DG's note. I do not confirm finding of the court on the first charge. I confirm finding on the second charge in sentence of the court. Now, pausing here for a moment, Milord. This is, Milord, as we say, I do not confirm finding of the court on the first charge. He is differing from a finding of a quasi-judicial authority by a single line. If the DG, it is his discretion not to agree with the finding. He has got a duty to give reasons. Lordship says, Lordship will see, Milord. Lordship knows, Milord. Supreme Court in repeated judgments has said that order must be supported by reasons. Unreasoned order is no order. And especially in case of, Milord, orders having penal consequence. In quasi-judicial proceedings are quasi-judicial, not merely administrative. He's not dealing with an in-house administrative matter, the DG. If he does not confirm the finding, that means this is the judgment in dissenting judgment. He is dissenting, then he has to give reasons. Because GS, the General Security Force could have give reasons in support of the finding of exoneration. He doesn't want to accept the finding, but he'll give reasons. Let the reasons be open to judicial scrutiny. Otherwise, my lord, what is there for a lordship to consider as to how this finding was arrived at? Therefore, this becomes totally arbitrary. This I do not confirm is totally arbitrary and capricious, whimsical. Court will take no note of it. Court will strike it down, saying that this, my lord, is in conflict with the consistent judicial view of giving reasons in support of any finding leading to penal consequences. Now, what has happened? And of course, he confirmed the finding of the second charge where I was held guilty. Now, the next provision in the PSF Act, this finding, after this finding, my lord, a further relief is given to an employee to make a representation against the finding. That is, my lord, at page 100, section 117. This is a remedy. Section 117.1 and section 117.2. Now, my lord, I tell you, Lordship, my lord, we shall definitely place this provision. Very, very simple, my lord. Only for this reason that 117 speaks of, my lord, gives a right to an employee to make a representation before confirmation. That means, my lord, as soon as the finding is handed down and before it is confirmed, under 117.1, my lord, he can make a representation. I did so. As soon as the sentence was handed down, this is to show that I exhausted fully the departmental remedy. No point can be taken that alternative remedy is available to me. As soon as those are on record, I'm just recounting it. As soon as the finding was given by the General Security Force Court, Milord, I made a representation. That representation, 117.1, was turned down. That is pre-confirmation. It was yet to be confirmed. Just the finding came from the General Security Force Court. Immediately before confirmation, I made a representation. That was turned down, saying that the authorities have decided to send this finding for reconsideration to the General Security Force Court. So at this stage, your representation cannot be considered. Saying that, they turned it down. Now they sent it to the General Security Force Court for reconsideration. They are also, General Lordship has seen, Milord, General Security Force Court, Milord, reiterated the element. The moment I came to know of this reiteration, I made again another representation. This is the second representation. That is yet to be confirmed. This second reconsidered finding was yet to be confirmed. So at the pre-confirmation stage, I made a second representation. That was turned down. Then, my lord, the DG's purported confirmation that I do not confirm finding on the first charge, I confirm finding on the second charge. After DG's purported confirmation, my lord, I made a post-confirmation representation. So earlier two were pre-confirmation and the last one is post-confirmation representation. Now, my lord, Lordship, my lord, will see how this post-confirmation representation is treated. This, my lord, should have been treated. I'll place your Lordship, place before Lordship the section. It says that this post-confirmation representation should be made to an officer higher than the officer who confirmed the finding. That is, my lord, DG confirmed the finding. So DG cannot sit in appeal over his own order. DG cannot sit in appeal over his own order. If I agree by the order of the DG, then I cannot appeal to him. It must be before a higher authority. So I appeal to the higher authority, that is the secretary in the ministry, Ministry of Home Affairs, central government, as per the act. But my representation was turned down by junior officer, saying that he was acting on behalf of the Director General. I tell you, Lordship, once more, my lord, the confirmation came from the Director General. Now, the section says that if the Director General is the confirming authority, then any representation against this confirmation should be made before his higher officer. Higher officer is the Director General. Accordingly, I made the representation before the Director General's higher officer, who can consider the order of the subordinate. So, Director General's higher officer was the secretary in the ministry, Ministry of Home Affairs. This representation of mine was turned down, should have been turned down by the Secretary of Ministry of Home Affairs. But then instead it was turned down by a junior officer, saying that he has been asked to turn it down by the Director General.
Where is it?
Well, I'll show it to your Lordship. This is very material. So, question is, my lord, where is this warrant and authority to do all these things? Lordship allows me to place it. Lordship wants to see the last one, my lord.
No, the one that you just now referred.
Yes, yes. So, first of all, Page 94. To whom I am making the representation. Page 94, Lordship got it.
Yes.
To the Secretary Minister of Home Affairs. He is an officer above the rank of DG. I sent it through proper channel through the DG. Then, this was considered by whom? Lordship kindly says. Page 104, 104. Last to gotten disposal of petition and signed by whom, Milord? 112. Kuldeep Singh, Commandant for Director General BSF. Who is he? How is the Director General BSF competent, Milord? To consider my representation against his order, which I made before a higher authority. He says, Milord, 112, turn it down, saying that Kuldeep Singh, Commandant for Director General BSF. They're totally without jurisdiction, usurpation of
The
authority.
representation was before the secretary.
Yes. Under the Act, Milord. I'll show to your Lordship the provision.
So, in reference to that representation, this order has been
Passed by the junior officer commandant, saying that he is passing it for the Director General. I made a representation before a higher officer under the Act. He is higher in rank than the Director General. It was disposed of by the Director General, not by that officer before whom I made a representation. And who under that should have considered my representation. This is my point before your Lordship. And Milord, Lordship kindly says me the tenor of the language, Kuldeep Singh for DG. It is not even signed by the DG. Nobody knows whether DG has any knowledge of this. His power is being usurped, assuming he has got any power. Usurped, I must say that the power of the central government, the secretary, has been usurped by a very junior officer in the service of the BSF. This by itself, Milord, constitutes a case of disciplinary inquiry. This is insubordination, going against the good order and discipline of the force. Making nonsense of the, I'm sorry, Milord, to use the very strong expression, of the mandatory provisions of the Border Security Force Act. Now, we're going to look at section 117.2. Any person subject to this act who considers himself aggrieved by a finding or sentence of any security force court which has been confirmed, means Milord, Director General is confirmed partly, which has been confirmed, may present a petition to the central government, the Director General or any prescribed officer superior in command to the one who confirms such finding or sentence, and the central government, the Director General or the prescribed officer, as the case may be, may pass such order thereon as it thinks fit.
Now, was that person the prescribed officer?
Prescribed officer, if he is a prescribed officer, I mean to say, these we have challenged in the writ petition, it is for the respondent to satisfy your Lordship. What is his prescription? Who authorized him to use up the power of the central government? He is just a commandant, very junior in rank. At this point, I am urging before your Lordship that my representation at the end was, also not considered at all. Just thrown out. So all through, infraction from the mandatory provisions of the Act and the rules. And lastly, Lordship will see that the 5-member bench. This is 5-member bench. Milord, Lordship will kindly ask to see the order. It is not signed by all the 5 members. It has been signed by only the presiding officer. So Lordship will kindly consider. Lordship knows Lordships are very often sitting in division bench. But the order is signed by your Lordships. One of your Lordships passes the judgment and the other member says, I agree. This is the usual procedure. And the Lord CPC says, Order 20, Rule 3, though the CPC is not applicable, but the fundamental principles are laid down there that any judgment should be signed. After CPC is off. Lordship looks once at Order 20, Rule 3. A judgment should be signed by a judge. And Milord, there is a division bench judgment. I shall. It says that unsigned order is no order at all. It's a nullity in the eye of law. Order 20, Rule 3. Judgment to be signed. At Joseph, they give him to. Rule 3. Order 20, Rule 3. Judgment to be signed. Very fundamental principles. Now they say they will certainly come and argue before a Lordship because the rules empower them to authenticate the presiding member to sign the order. So, Milord, authentication very well. But thus, authentication can be stretched to mean that the other members need not sign the order. This will Lordship will kindly decide what is the effect of this. And assuming, Milord, your Lordship is inclined to accept this order of the other members of the General Security Force Court. They have given it the nomenclature of court, Milord. They should behave like, Milord, judges. But assuming Lordship is inclined to accept this, then also, Milord, there is no getting away from the provisions of, Milord, this voting by members, deliberation of members, recording the views of individual members. These are all matters of record. If no record is produced before Lordship, then Lordship will certainly hold, Milord, that here there is a very serious failure of justice, and Milord, such a procedure cannot be countenanced, and so the sentence is vitiated. Entire proceeding before the General Security Force is vitiated. And Milord, these are the provisions in brief. The submissions in brief. Now, one thing I must tell you, Lordship, Milord, natural justice was breached in every stage of the proceedings, Milord. But one thing must be said, Milord, in support of the authorities, that I wanted to be represented by an outside lawyer. Initially, as representative of departmental, what they call, assistant. Then, Milord, I made repeated representation that let me have the assistance of an outside lawyer. That is allowed. So they allowed me after examination of 4 prosecution witnesses as matter of record. They did not allow me at the beginning, but after the examination, cross-examination of 4 prosecution witnesses out of 15 was completed, then I was allowed to, Milord, take the assistance of an outside lawyer who conducted the rest of the proceedings. Now, as far as the judgments are concerned, Milord, shall I proceed today or?
Next date, sir, let them be there. So they're appearing with the case records. Maybe next date we'll ask them to.
Kindly, Lordship, kindly. Milord, these are the initial things, Milord, they should satisfy Lordship about. If they can't satisfy Lordship about, Milord, then Lordship will draw Lordship's own conclusion.
But there has been an initial statement by the petitioner. That is also there on record, sir.
Yes, that's right. That is there. But the question is, Milord, I tell you, Lordship, assuming I'm a very bad man. But the question is, Milord, try me in the proper procedure. My trial should proceed as per the laid down procedure, the act and the rules. If that is faulted, if a lordship finds that there is a serious deviation from the act and the rules, then, my lord, the obvious, my lord, the results will follow. If there is a serious deviation from the act and the rules, number one. And secondly, my lord, apart from his statement which came at a later stage and which really, my lord, was focused on the legal aspect of the legal aspect. It was drawn by him, the legal aspect. But then the evidence of the doctors, which is contemporaneous in nature, that, my lord, cannot be lost sight of. The evidence of the doctors in repetition. In repetition, the doctors gave the evidence. That cannot be lost sight of. Whatever, my lord, may be the aggravating factor for, my lord, for me.
So there is one page 113.
Yes, page 113. I'm obliged to your lordship. Yes, page 113, my lord.
Not 113.
Yes, this is an order, 10th September, etc., 22nd October 2027. Eastern headquarters with permission of the commandant above order is subject to confirmation central government. So these orders are there. Correct.
This one.
Lordship is looking at what Miller is trying to find out. Paper. I can assist you, Lordship.
No, I had just.
I perhaps, Lord, I know it's passing through Lordship's mind. Lord, let me try to assist you, Lordship, Lord. Is it, Lord, at page?
No, 232. Sorry.
229.
232 of the
Yes,
evidence,
229
the
stuff.
entire portion of the medical documents.
Oh, 230, 232 there. 232. Yes. 232, yes.
The individual is examined today on MSc. No gross psychiatric problem is detected. The present physical weakness is partly due to boredom in work, partly due to viral fever.
Correct.
In my opinion, he may be allowed to change his working place, which will help him to help him recover from this condition. Advice, continue treatment.
Correct. Obliged to you, Lord.
Next
these
page,
was-
handling of arms and ammunition strictly prohibited.
And this was as per Bagas.
Yes, 233 was a page that I was.
This is 24 July 2007. It developed later on.
Yes. Thereafter, in page 233,
Yes.
there is this 113 written.
Yes. These are the discharge
In the,
advice.
yes. A case of MDD was under treatment from psychiatry OPD of NBMCH since 28th of July 2007. Since had been under regular follow-up on a
attaining convalescence
was it's the continuing portion is not properly written, was attaining convalescence at such and such Tola since 16/8 and advised by the specialist. He has become anthemic and he is considered fit to resume duty by treating psychiatrist but without arms and ammunition.
So I resume my duties. because I was then slowly recovering. Then the incident took place. My lord, prescription of this is at page 56. 56, this is the discharge advice, and page 56 is the prescription. If your lordship turns to page 56, we read together. So there is no denying the fact that I was slowly recovering. I was on the way on the all on the way to the full recovery.
So there is another page 239.
239. Yes. The individual, etc. This and that regarding
Department of Health and Family Welfare,
the
Government of
23rd October, much after,
23rd October 2007.
much after the incident. Incident took place in 10th September 2007. Then he was slowly recovered. After that, he was in medication, hospitalization, treatment, all this. This is the thing, course of events. Entire thing was whatever may have happened, Milord, whether Milord, this mandatory procedure was properly followed, and if not followed, what is the legal effect of this? What is the legal effect? And lastly, Milord, Lordship will consider that aspect of the matter also. Milord, that calls for Milord Lordship's consideration as to whether what he has done, having regard to what he has done, and if the section permits it, this punishment is called for in the circumstances of this case. Lordship can briefly looks at section 40, Milord, once before I leave, Milord, only section 40. Under this section, he was punished. Right? Now, 40, section 40 is the section of which the violation is there. Violation of good order and discipline. Any person subject to the act who is guilty of any act or omission which though not specified in this act is prejudicial to good order and discipline of the force shall, on conviction by a security force court, be liable to suffer imprisonment for a term which may extend to 7 years or such less punishment as in this act mentioned. So 7 years or a lesser punishment. Whether, my lord, this punishment of dismissal from service is contemplated here. That is the thing the lordship will kindly consider.
Okay, sir. We'll continue.
Charging section is section 40.
6 months he was confined
Yes.
and thereafter released by the order of this court.
Yes. That is so. And dismissal from service at once. Dismissed from service. And not only that, Milord, I have been associated with this case from 2009. Milord, I remember we had to go before Justice S.P. Talukdar, where, Milord, some payments due to him were withheld. Subsistence allowance and messing charges, Milord. Milord, we had to obtain order from that. I appeared, Milord, with Justice S.P. Talukdar, and Justice Talukdar ordered immediate, Milord, release of the funds. That was way back in 2009 or 10.
So what must be his age now?
He is naturally is advanced in age, but Milord, there are various ways of, Milord, if your lordship, whatever conclusion, I do not know, Milord. The question is, Milord, if your lordship finds that the punishment is not called for, Milord, then, Milord, is for the authorities to decide how they will, Milord, accommodate him, or what next will follow. 46. Still, Milord, some more years to go for service. Very many years to go for service.
Yesterday, Mr. Chatterjee said that he won't be
Here, but
Hearing.
junior will be here.
His junior will be here, but today I don't find anybody. The learned advocate representing the respondents, BSF, is not present. Heard the submission of the learned advocate representing the petitioner at length. Next date be fixed on 5th of August, so that I can ask them to place the
Records.
records.
5th of August.
Only for this part, sir.
Only
Only restricted to this issue that they will produce the records.
records.
And thereafter the date will be fixed for further hearing.
What did they communicate? Milord, we shall communicate the order, Milord. Lordship kindly gives me the liberty to communicate the order to them.
No,
But-
sir, on that date only I will give the
No.
order.
Lordship's order for them to produce the records on the day.
Not on that date. In their presence only, I'll ask them to place the records because they carry the records to court every day. That is what Mr. Chatterjee said yesterday.
Milord, since they're absent today, we shall communicate today's order to the learned advocate
That you can do.
in writing. 5th August. Milord, any time fixed by Lordship?
Sir, it
Fifth.
will take few minutes, 1 or 2 minutes. I mean, I will just ask.
Much. 5th of August.
Sure. Let the matter be adjourned for the day.
Time for the petitioner, my lord. Last occasion, my lord, your lordship, my lord, directed to submit a report, my lord. Last occasion, they have also not appeared, my lord. Thereupon, your lordship.
Today again there is a resolution.
Yes, ma'am.
They have not appeared. Yesterday you were also not there.
Yesterday, no, my lord, matter was not
Not
released.
yes, on 31st.
31st, I was there, my lord. I was there, my lord. They was not appear, my lord. On virtual, my lord, they appear, my lord. Your lordship not heard, my lord. I appeared, my lord. 31st, I appeared. 31st, I appeared, my lord. My lord, state is not. So, my lord, your lordship.
Learned advocate representing the petitioner is present. None appear to represent the state. Respondents, let the matter be adjourned for the day. The correction করতে হবে পরে।
Instead of Monday, my lord, your lordship is Tuesday, my lord.
5th of August. Any you are here for the claim applications?
I've got two, 4 orders. Yes, claim applications. 4 orders.
My lord, for orders.
It's not your matter is separate from theirs.
3, 4 orders can be disposed of. That is what we would track.
The ones which you had yesterday. The absentees of yesterday.
Yes, the absentees of Mr. Mondal was not here. He had a medical emergency. So, we spoke if you can do even 1, 2 of that.
Which are your mothers? Which are your matters?
One is,
Mr. Pahadi.
No, Saha. No?
No.
188, 189.
188, 89.
This is appeal of insurance.
How come you are here today? On a Saturday too? Oh. So I was wondering, the moment I saw you, I was like, is the sun aware of its position?
Even I was anticipating that this question will be put. So ready with the answer.
Well, and Mrs. Gopalash Mukherjee is also here.
No, she had her bit in the very first. It's the effect of yesterday's scolding.
Yes, yes. Not even if one or two matter can be disposed of.
Yes, yes. Whoever you are there, we'll dispose it of. Now, 208.
Not 208, not this day, not I won't do it today, not 208.
Who is your other side?
Not New India, soccer.
হয়নি তাহলে রেডি নয় আর কি 204 205
204 205 we are there, Mr. Singh, and
you are there,
but yes,
so then 1 2 3 4
Malad 204 205 perhaps wouldn't be disposed of today. 210 211 we will do.
188, 189 and 210.
211 who is your other side?
I am there.
And for 210
I am there.
who is Shujit Shah?
Malad, he's outside, he's coming, Malad.
And what about Shoikot Sen?
Malad, he is the advocate on record in item number 204 205. Malad, the difficulty is that the paper book, I had taken documents from Mr. Singh. It's a bit illegible. So, Malad, he was suggesting if we can file a fresh paper.
TCR is there.
Yes.
If this TCR is there,
Malad.
then we'll do it.
Malad.
Then we will not do it today, we will do it Monday.
Why you have not read? You read it. It's a good opportunity, Mr. Singh. We can dispose it of today itself. 1 2 3 4 5 6. Yes.
You will keep it for the last minute. I'll try
Yes,
to go
yes.
through it.
After 2, you take your time, read it.
188 189.
I'll try. I'll try not mind.
Have a nice time after 4 o'clock today. Yes.
Item number 155, my stay may be confirmed, my lord.
That's exactly what I told her yesterday. You will come for getting the stay order and thereafter vanish for us.
List, my lord.
Come again. What did you say?
Some days I miss.
Some days.
It's the other way around.
My lord, I've got so many orders from your lordship that I'm not.
Don't, no buttering. What is your number?
My lord, item number 155, my lord, and 121, my lord. I have received the paper book, my lord.
155 is your?
155 is confirmation of stay order, my lord.
And which one is the earlier one?
121, my lord. In 121, it is insurance company appeal. I have received the paper book, my lord.
Who is your other side?
Jantukumar Mandal.
No, he said that yesterday their quota was
My lord, then
fulfilled. No, that is what they said.
can you keep it on Tuesday or Wednesday, my lord?
Cancellation. Now, then let 121 be in the list as it is. You
Again on Monday it will appear again. I'll be called on Monday. I'll not be here, my lord. On Tuesday, my lord, your lordship please, my lord. On Wednesday, my lord.
now I have to record the absence of the other side.
On my request, my lord. On my prayer, my lord.
The learned advocate representing the, because I'm not calling the entire list
I
today.
appreciate, my lord, but
So we will list it in with a date. So that will not.
I'm ready.
Because they were there yesterday,
Fine.
they did their bit and they requested me that they won't be present today. I said, okay.
Fine.
Your appeal is in time
My
in 155.
155 stay has been
Record
granted.
tache
I'm what has
155.
been deposited. I'm handing over the challan, my lord.
So 155, no? Four weeks, issue notice, file affidavit of.
My lord.
This is not for the first one.
No, my lord. Stay has,
Where is your affidavit of service?
my lord, it is not affirmed. I have served already, my lord. Next day I'll file the performance.
Was it served?
My lord, it has been served, my lord.
The learned advocate representing the appellant insurance company submitted to have served notice upon the respondent claimants, however, none appeared to represent the same. In any case, if you file the affidavit of service, then also they won't be able to come. Next day, it won't be known to them.
My lord, if your lordship
The
directs,
administrative notice we sent. The learned advocate representing the appellant insurance company is to file the affidavit of service on the next date of hearing. Next date, which district?
my lord, it is Bankura.
Bankura. Next date be fixed on 19th of September.
I'm grateful, my lord. My lord, my challan has been
State absolute.
challan has been deposited. I'm grateful.
Yes, madam.
161, my lord, item.
For what? State to be made absolute. Where's your challan? You have filed the affidavit of service. Same order. Where's your affidavit of service? Affidavit of service filed by the learned advocate representing the appellant insurance company be kept on record. Yeah, 90, which district?
110.
Oh, yeah, date 19th of September. You have any application?
163, my lord.
163. You filed the challan? Affidavit of service filed by the learned advocate representing the appellant insurance company be kept on record. Stay to be made absolute. Which district?
South 24 Parganas.
9th of September. 164. 164, 165, 166. So you are not coming on Monday then? Is it same? You tell me the districts. Which one?
164.
Acha. 164 at data. 164, 22nd of September. Now, have you filed the affidavit of service? Affidavit of service filed by the learned advocate representing the appellant insurance company be kept on record. Stay to be made absolute. Notice on 22nd September. And 165 is from which place?
Kolkata.
Kolkata. You're filing the affidavit of service?
Hi.
Challan you have filed? Affidavit, Aki order, Challan, stay absolute. Or Kolkata, 3rd of September. 166?
3rd of
September. 166 you have, is yours?
yes. And 66 is Paschim Bardhaman.
Bardhaman? আগে তো একটা পশ্চিম বর্ধমানে কপি না তার আগে একটা পশ্চিম বর্ধমান ছিল
1990.
Then this one also on 19. Your filed affidavit of service? Challan?
I'm grateful.
You don't have any matter fixed for orders? You were there yesterday. Yes. Any other applications from any one of you? Why, what's your problem? Then why have you come today? I haven't come for 1 week. Mr. Singh, the price of butter has plummeted. Okay, for orders.
Order site number 185, Your Lordship, the first matter.
রিপোর্টটা চেঞ্জ হয়ে আছে অর্ডার তো দুটো থেকে হয় না Madam, your other side is not there.
Lordship, I asked him to come. He came at 4, Your Lordship, before Your Lordship. I told him that the matter will be taken up tomorrow. You have to be present. At any consequences, you have to be present.
দেখি অর্ডারটা কি বলেছে
Today morning also I called him. The 2019 matter, Your Lordship, that should be in every occasion, Your Lordship, in one pretext or the another, he ignored this court, Your Lordship. Every time, Your Lordship. In the morning also, I called him.
But today, I mean,
Lordship,
in
I know the
absence,
resolution is there, Your Lordship. I know
that is why he has not come.
No, your lordship, he will never come. I know that because
But then,
yes, your
madam,
lordship,
the
actually your lordship asked
the
me to come
rest-
as the petitioner. I have some
but
obligation.
since you had brought him along with you in the evening, so I asked them to fix it today in anticipation that he will be present.
So,
Now the resolution is there, madam.
Lordship,
Monday in any case.
lordship, at 2.
Okay.
Your lordship.
The learned advocate representing the petitioner is present. None appear to represent the respondent. Let the matter be fixed under the heading for orders on 4th of August. 4th of August, in any case, I'll finish it off if he doesn't appear also. And I probably had told him also that.
Lordship, I told him yesterday night, today morning, Lordship. They are taking full advantage of the resolution every now and then, your lordship.
188, both of you are ready?
Yes. Hey, Milord, appeal of insurer.
Yes.
It's a death case, Milord, mainly on the ground of non-involvement. Milord, the principal award of 6,76,000 for this.
Paper book is there?
Yes, Milord.
Yes, my lord. It has been filed. Filed.
Paper book ding. Yes.
Milord, it is mainly on the point of non-involvement, and Milord, the claimant's cross objection is for enhancement of the award itself.
Non-involvement in
The-
which ground?
Milord, non-involvement delayed FIR.
Delayed. How many days?
Milord, initially, Milord, the first the written complaint was lodged, Milord, 54 days after the accident, without any or without reference to any number, and thereafter,
Without reference to number, yes.
Milord, after 7.5 months, the number was given for the first time by a subsequent, Milord, complaint.
By a subsequent complaint.
Lordship.
Now, investigation proceeded on the basis of which complaint?
Second complaint, Milord. The first complaint, Milord, the number was not there, nothing happened. It was against an unknown vehicle after 54 days, Milord, the father of the victim. Milord, it's the 7/11/2017 is the date of accident. Milord, victim was a bachelor. The parents are the claimants. Milord, the father took him to the different hospitals. Milord, he was in hospital for a considerable day. Milord, he died subsequently on 30th/12/2017. 30th December 2017. Milord, this is 53 or 54 days gap. Milord, the day he died, the first written complaint was lodged after 54 days. In the written complaint, Milord, it was about a Aujana Gadi or Milord unknown vehicle. Whatever, Milord, the proceeding was on by the police, we are not aware. It was on paper or on document. And then, Milord, on 25th June 2018, there was a subsequent complaint, Milord, wherein, Milord, as per the charge sheet, it shows, Milord, wherein for the first time, Milord, this name of offending vehicle was brought into the picture by the same gentleman, the father of the deceased, who lost the first complaint. May I just show it to your lordship, Milord? Milord, first of all, Milord, the date of accident that
now,
is
you had taken this plea before the tribunal?
Lordship.
And how did the tribunal deal with it?
Milord, the award of tribunal, Milord, starts at, Milord, page number 28.
Yes.
Milord, I'll Milord, take Milord 2 minutes time, Milord, just to show Milord this series of Milord these incidents, Milord, how they have been placed. Written complaint.
Yes.
My lord, the written complaint, my lord, the first of all, if my lord kindly comes to, my lord, page number 22.
This is the first one.
This is the first one, my lord.
Page number 20.
22, my lord. 22.
Now, you see, received on 30th December 2017
Lordship.
at 10:45 hours
Well.
and started Dum Dum PS case number 1286 of 17 dated 30th of December 2017 under section such and such.
Lordship.
Now, what was the fate of this?
My lord, this is what, my lord, I'll take your lordship too, my lord. After this, my lord, nothing materialized. My lord, then the second one, my lord, the victim's father subsequently, my lord, after
What
7.
does the charge sheet mention?
My lord, charge sheet, my lord, is at page 26.
Which date of the complaint in the charge sheet?
Lordship will kindly say, my lord, page 20. My lord, is charge sheet, my lord. The charge sheet starts at 23. My lord, the detailing portion, my lord, is at page 26.
No, it doesn't mention. Yes, it mentions, sir.
Yes.
30th of December
Yes.
2017. So
Yes.
they have acted on the basis of the first complaint, not
Nothing
the
found.
second.
No, I didn't say that actually, my lord, the first complaint, it was written complaint was there. It was absolutely, my lord, with regard to the offending vehicle reference, it was absolute silence. And then, my lord, after 7.5
What was
months.
the offending vehicle? Motorcycle?
No,
No,
it, my lord, it was
Tata 407.
Tata 407. Mini truck, my lord, it's a mini truck.
In page number 23,
Lordship.
it says one matte blue Apache.
That's the victimized motorcycle.
The victim was riding a motorcycle.
So that was seized. So-
Subsequently, the offending vehicle has also been seized.
But that has not been mentioned in the season.
It has been
It will
mentioned.
be there subsequently, my lord.
Well, it comes to page 27. 27. Tata 407 bearing number such and such. 25G9900.
Belgorria. In page number 25, it is mentioned. Serial number 11. I mean,
Yes.
which is a continued one. One
Yes.
vehicle Tata 407 with bearing registration number such and such.
And the
Yes.
Caesar list is Caesar is at page 27 of the
Caesar.
paper book. Of the offending vehicle, Tata 407, 27 is the Caesar list of the vehicle. It was done on 30th December 2018.
My lord, to simplify the things, my lord, 7/11/17 accident, 30th 12/2017 after 50 days, first written complaint against an unknown vehicle. And then, my lord, if I invite my lord to this very charge sheet at page number 26. The next, my lord.
এতদিন আমার ছেলে পিজিতে চিকিৎসাধীন ছিল। আজ রাত 12:27 AM তে আমার ছেলে পিজি হসপিটালে মারা যায়। অতএব আমার ছেলের চিকিৎসার কারণে আমার জিডি করতে দেরি হলো। এর জন্য আমি
ক্ষমাপ্রার্থী ঘটনার
তদন্ত করিতে যথাযথ
আজ্ঞা হোক।
So, my lord, till this date, offending vehicle remains unknown. Now, my lord, if my lord kindly comes to page number 26, my lord, is a running charge sheet. In the middle.
Yes.
Third paragraph, my lord, or fourth paragraph, starting on 25/6/2018. My lord, then this particular day comes into the picture. This is, my lord, 7.5 months after the date of accident, that is 7/11/2017. November 17 accident, first week, and 25th June 18. My lord, on 25th June, Miss my lord, there, my lord.
Yes.
On 25th June 18, the complainant Niranjan Saha filed a petition with affidavit before the learned so-and-so SEJM, praying for further investigation. He mentioned in the affidavit that he got information about the offending vehicle from one Achin Saha and two Uttam Goa, and he said that the number of the offending vehicle is this 9966. 7.5 months after the accident, my lord, this 9966 is coming into the picture for the first time. Till then, everything is silent. And then, my lord, the ball starts rolling after this.
This Achin Shah and Uttam Guha, they have been cited as
Yes, charge sheeted witness.
My lord, they would be because, my lord, because then, my lord, everything is being set up. No, after 7.5 months, this is where the difficulty arises. My lord,
Okay, this
now,
will
my
be
lord,
on
I'll show.
only ground or
No, my lord, I'll show, my lord, the further, my lord, instances, my lord, how it has this setup has been made. My lord, your lordship, my lord, kindly come to, my lord, page number 15. My lord, this is the hospital staff where the victim was treated.
Hmm.
My lord, he was there, my lord, accident on 7th. He was there from 8th. The next day, my lord, he was there for a
which page
fortnight.
did you say?
Page 1515, my lord.
Yes.
My lord, I am Jontu Nag.
Hmm.
I am the administrative staff now posted at TRA hospital, my lord, where the victim was taken. My lord, the subsequent paragraph, my lord, one after that, it appears from our official document that victim Shorav was treated in our hospital from 8/11 to 27/11. My lord, the cross-examination, lordship will kindly come to. Second paragraph. It has been noted in the history of the injury that patient at the time of accident was riding in a motorcycle. He hit a roadside shop and got head injury and only trauma. And polytrauma, I'm sorry, my lord. The same has been reported in the treatment sheet. Initial hospital records when the victim was taken, the first, my lord, instance, the very next day or the day after the accident, my lord, he was riding a motorcycle, he hit a shop, no other vehicle involved, he suffered injury, and he was there in hospital.
Hmm.
My lord, in our written statement, my lord, or in our evidence of the insurance company, if my lord will kindly come, my lord, to page number 19.
Yes.
My lord, paragraph 3, my lord, the sub-paragraph, my lord, paragraph 4, my lord, I have, my lord, stated, my my lord, the insurance company's officer has stated about, my lord, this anomaly, and then lordship will kindly, my lord, come to paragraph 5, page 2020. My lord, that the claimants of this case at times of evidence have filed some papers of RG Corp, and the same was exhibited by this learned court as Exhibit 2. And in that document, it is clearly written that the injury of the patient Shorav and further the evidence of witness, namely Jontu Nag, that is PW2, my lord, what I have shown to your lordship, from the TRA General Hospital, and the said witness filed some medical papers, that is letter addressed to officer in charge Korea station regarding information about the accident, treatment sheet of the patient, and other medical bills. That in all the aforesaid papers, it is clearly mentioned that according to patient party, patient was riding on a motorcycle. Accidentally, he hit a roadside shop and got head injury and polytrauma. And in the admission form of that hospital, Niranjan Saha, the father of the patient, put his signature.
Hmm.
Similar. This is what has happened. Till 7.5 months, this was the picture, which was, I believe, was the correct picture. Because the hospital record was also signed by, the father of the victim. Now, to prove their case and to substantiate their allegation, they have brought one witness, eyewitness. This eyewitness, has come up, at their instance, Uttam Shah, which, obviously, was a charge-sheeted witness, because charge-sheet, was formed after 7.5 months, when the vehicle number was put in. This Uttam Shah, page number 16, if my lord kindly comes to 16, his evidence, eyewitness, the sole eyewitness, my lord, so called. I'll state with the other facts are there. He will say that yes, it was in front of me. The very last paragraph of this page, page 16. I do not know Shorav Shah, that is the victim or his family. Afterwards, I informed the car number to the police when they called on me. Most probably, your lordship will kindly see. Most probably it is 3-4 days after the accident, and I have informed the same to the police station. Now, my lord, this eyewitness, the sole eyewitness to the accident, informs the police most probably after 3-4 days. If it is not 3, it is 4, it is not 4, it is 5, it is not 5, it is 6. So within 3, 4, 5, 6 days, my lord, if I take him to be true, my lord, the police is aware of the vehicle now. This is what he comes up in witness box and he states. Till 54th day, and in all hospital records, my lord, the offending vehicle is nowhere. He has seen this accident and he informed about it to the police. That's what he says. 7.5 months after the accident, my lord, for the first time, my lord, this offending vehicle is brought into the picture. There is an absolute case of, my lord, vehicle implantation. This is entire evidence, my lord, and on the basis of charge sheet and this eyewitness's statement, my lord, that yes, he saw the accident, this vehicle was involved, my lord, my vehicle has been, my lord, directed to pay compensation for confirming the involvement. And, my lord, on this entire series, my lord, I've shown to your lordship, when the father himself, my lord, in the hospital record doesn't mention anything about it. My lord, he doesn't even know, or rather, my lord, he didn't, there was no other vehicle. He hit a shop. He was riding a motorcycle. He was 21-year-old boy, my lord. He hit a motorcycle. Parents are the claimants before your lordship.
This is your only ground.
This is my only ground. Yes, this is, my lord, for non-involvement.
Why have you filed the cross objection?
My lord, multiplier should be 18. It has been taken as 17. Income, my lord, I had claimed 5,000. It has been taken as 3,000. Future prospect should be 40%. These are my grounds in the cross objection.
Multiplier,
My lord, income
income.
and future prospect.
Why do you claim enhancement in income?
My lord, accident occurred in 2017. My lord, 21 years old. I obviously, my lord, said in the claim application that he is self-employed. I could not prove that. But my lord, 3,000 in 2017, it should be, even if it is notional income. 21, my lord, perhaps he was not employed. He was perhaps a student only. So, but even as a notional income, 3,000 in 2017 is much less, my lord. So I'm praying enhancement on that account. Notional income, but 3,000 is less, my lord. I could not prove any documents to prove the income. He was 21 years old at the time of the accident. Now, my lord, regarding the delay in the FIR, I can explain, my lord. It is true that 54 days after the accident, the first FIR was done. But, my lord, the victim was alive for 54 days. On the 54th day after the death in SSKM hospital, the father went. My lord, in the written complaint, the father mentions
That I've seen.
Ekti Ojana Gadi. Now, my lord, the eyewitness,
Eyewitness Uttam Guha,
yes,
he had reported the number to the police.
yes,
Within 3 to 4 days of
yes, that is what he states in his examination in chief. Now, my lord, in the charge sheet also, it is mentioned that on 25/6/2018, the complainant Niranjan Saha filed a petition with affidavit before ACJM Barakpur Court praying for further investigation. He mentioned in the affidavit that he got information about the offending vehicle from Achin Saha and Uttam Guha and stated that the number of the offending vehicle being such and such. The complainant also submitted a petition before Damdam PS in which he mentioned the offending vehicle bearing registration number such and such. So, well, this Uttam Guha is a charge sheeted witness. My humble submission is only one, my lord. This Uttam Guha appeared before the tribunal. He has been cross-examined. Kindly, my lord, Mr. Singh read out.
Victim Saurabh Saha.
No, he says, my
Of the victim is Saurabh Saha.
Yes. My lord, it says for the my lord, kindly PW3 is at page 16. I did not know the claimant, Ratna Saha. I am not a summoned witness. I have seen the road accident at about such and such. I have filed my written examination in chief. In the cross-examination, my lord, nothing adverse has come. If he is a charge-sheeted witness, my lord, kindly see the cross-examination at page 16. He has mentioned in detail At the time of the accident, Saurabh Shah proceeded from the side of the airport to Dunlop side. The offending vehicle was coming from airport side to Dunlop side. At the time of the accident, in the place of accident, there was a divider. Silver bar is situated at the side in which the accident took place. So, my lord, nothing adverse has come. Secondly, my lord, two other things are there. Mr. Singh also relied on, at page 15, he relied on Jhontu Nag, the employee of the hospital, who said that the history was there that he hit a roadside shop. Mr. Singh did not read the subsequent paragraph in which it is stated, in my opinion, it is not possible for me to say that Saurabh Babu met an accident with a car. Of course, my lord, he was not an eyewitness. His father did
So
not.
he meant to say probably that the hospital records did
Yes.
not state
Yes.
there had
About
been
the another car being hit by another car.
there had been an accident with the involvement of another
Yes,
vehicle.
my lord, my exact point is that it is very clear, my lord, he was taken to the hospital by the onlookers. He was not taken by his family members. He was neither taken by Uttam Guha. He was taken by the people who were there. Who supplied that information? That should have been in the cross-examination. Uttam Guha should have been asked. Secondly, my lord, the owner of the vehicle, they filed 170. They are contesting the case on each and every single merit. They did not summon the IO. They did not summon the father of the victim. My lord, father of the victim is the FIR maker. PW1 is the mother of the victim. She stated about the accident. If they are saying that these documents, the father of the victim went into the hospital and stated these facts, then the father of the victim could also have been brought to the witness box. They did not summon that also. They did not summon the owner. They did not summon the eyewitness. They did not put relevant questions to the to the eyewitness as well. The only eyewitness. They didn't. There are other witnesses at page. My lord will kindly see page number 25 lists other witnesses. None of those witnesses have been called for. Even if we assume that Uttam Guha is my person, in collusion with Uttam Guha, I have filed this case. There are other witnesses they could have informed. They could have summoned the other witnesses. None of them have been summoned. Well, the mechanical inspection has been done of the vehicle. That mechanical inspector could have been done. They have adduced evidence of the employee of the insurance company. But the mechanical witness inspector, if they were doubting it, the mechanical inspection is part of the case diary. They should have challenged it. They did not challenge it. Kindly see page 25 once. The witnesses, the seized documents. Well, under section 168, the tribunal itself is the inquiry officer. I have not suppressed anything. All the documents, all the witnesses are before your lordship. They should have, after filing 170, they should have summoned these witnesses if they are doubting the genuinity of the accident.
Okay. কে আছে এখানে?
My lord, it is their case to prove how the accident had taken place. My lord, the hospital records, which are not a part of this paper book, my lord, hospital records, my lord, say the father himself has signed that yes, only the motorcycle and, my lord, the shop is there. Other vehicle is not there. The same father.
It is admitted, but father is not the eyewitness.
He did not, my lord, he
did
chose not to come before the court. Why shall I drag the father?
Why not? Because it is your
Their
case.
to prove their case, my
The
lord.
tribunal has believed
It is
me.
not my case. They have come to the court.
Well,
What did the tribunal say?
yes. My lord, kindly see page. It starts from 32, but the finding of the court is at page 32.
Yes.
He categorically stated. After that, the PW3 Uttam Guha, middle portion, my lord. 32.
শুধু নোট করেছি আমি not considering page 33, considering all evidences on record, pleadings of parties, page 33, last but one paragraph, last third paragraph. page 33. Considering all evidences on record, pleadings of parties, rulings cited, and argument, I am of the view that the petitioners have been able to establish their claim by cogent and convincing evidence. And my lord, over and above that, my lord, he has simply recorded who said what, who said what, who said what. My lord, the father was not brought to the court. The eyewitness, the sole eyewitness with whom they tried to prove their case, he said that I have informed the police after 3-4 days. And police is silent, my lord, for 7.5 months.
Lord,
nothing can be more glaring than this.
Lord, 4 tests has been laid down in the case of Birender, which they will have to satisfy if they file 170. My humble submission, my lord, is out of those 4 tests, Mr. Singh's client has not satisfied even one.
Lord, if TCR is here, my lord, just lordship can also, my lord, if it is not a part of this paper book,
TCR
the lordship will kindly send out the hospital records where the father himself has signed, my lord. This is what, my lord, the hospital gentleman came and, my lord, stated. Exhibit what?
6 হবে বোধহয়।
Exhibit 2, 3 মধ্যে হবে 1, 2 and 3. Injury report of Saurav Saha and postmortem report 2 and 3. Medical papers 6. Medical papers 6.
Exhibit 6
are 2 and 3. RG Kara Rota. Exhibit 6
ওনার কাছে সার্টিফাইড কপি বোধহয় ছিল না।
This Uttam Shah, my lord, told police after 4 days, and he informed the father after, my lord, 7.5 months.
The father was busy attending to his dying son
For 7.5 months?
for 54 days at least. The father did not know the eyewitness.
কোথায় টিসিআরটা? The outdoor patient document
Yes,
that is marked as Exhibit 2.
yes, yes.
It's on the reverse page. It says a case of head-on due to RTA.
Yes, yes.
But of course, RTA, road traffic
My
accident.
lord, till 7.5 months, no mentioning of any other vehicle.
History RTA has been
Yes,
mentioned.
that is what I accept that. That is what my case is. My lord, he hit a shop. That is what their case was till 7.5 months.
আমরা মেনশন করিনি hit a shop. I have said অজানা গাড়ি।
Hospital record.
Hospital record, the person might not know.
And we do not actually know who took him to the hospital.
The lordship will kindly say, my lord, in the hospital, my lord, whose signature is there?
Signature is there. The person who took him, his details won't be there. But it was certainly not the father.
It's not mentioned. The doctors
Doctor has mentioned that.
stabilize. I mean, generally what happens
Yes,
in
yes.
emergency counters
Yes.
in the hospitals.
Most important point, my lord. The victim was alive for 54 days. His father or his mother, this question should have been put to the eyewitness that if he knew, they did not put the proper questions to the eyewitness. The IO who has filed the charge sheet on the basis of the reinvestigation order, the owner, the driver, everyone's detail is mentioned.
One Dr. Joyanto Chakraborty, has he been cited as a witness?
No. No.
Of TRA
Lord,
General?
Mr.
No.
Jhontu Nag, the administrator of TRA, has come up as a witness.
Prove the bills. 3,20,000 odd bill was there. 3,40,000. He came and proved that.
And he also said that what the hospital record said.
Yes.
You brought him for my lord, he gave evidence, and now you say you do not like the evidence.
No, I do not say. I accept his evidence.
He said that it was mentioned that he hit a roadside shop.
It also says, in my opinion, I cannot say whether the accident was caused by a car because he is not an eyewitness. He can only depose to the extent what is written in the document. But he was not an eyewitness. He is not privy to that information. They have not summoned the witnesses who were privy to the
What is
information.
noted in the my lord record.
Yes.
He has stated that.
There's no question of denying it, my lord. The person who had the relevant information, eyewitness, kindly see the cross-examination of that eyewitness. And he states at page 17, I never took Saurabh to hospital. And he further states, I had received information of death from his father.
Yes.
My lord, eyewitness knew about the accident. Eyewitness informed the police about the accident. Eyewitness informed the father about the accident. And my lord, this entire thing took 7.5 months, my lord, to culminate. Police did nothing. Father, my lord, the date of the knowing of the information is not given, my lord, but the eyewitness knew about it. And he said he only informed the father. Father says that. Eyewitness informed me. My lord, for absolute blank, my lord, and 7.5 months thereafter, my lord, the ball starts rolling.
Okay.
November
17.
2017. My lord, firstly, he was taken to Archikor, then to TRA hospital, from there to SSKM hospital.
Yes. Yes. Minute. Lordship.
Yes.
That there was a delay on page 8. Inside of that, paragraph 30.
Lordship. Lordship.
But I was submitted that even because argument it is argued that though not treated that they are because there is a very persons are more involved in the accident. But it is most restrictively submitted that it is an aggravated position from the FIR that at the time of the alleged accident, the deceased was proceeding by driving a motor vehicle and therefore he had also had contributory negligence towards the happening of the alleged accident.
If any.
If any, therefore, I mean, you take so many things, ifs and buts.
Milord, in written statement, your Lordship knows, Milord, each and every allegation, Milord, is to be denied, Milord, Lordship. Lordship.
You have not pinpointed your exact contention. You are just assuming from one.
Milord, I take all precautions. Milord, I deny every single thing, whichever, Milord, I do not admit. But that's what Milord, we do, Milord, in suit drafting, Milord, in written statement. Milord, we deny every single thing, Milord. Your Lordship knows that. Unless, Milord, it is specifically admitted. Because, Milord, if we do not deny, then again, Lordship.
Evidence of the eyewitness.
Milord, is at page number 1616, Milord? Milord, yes, Chief, and cross.
The second line of the cross examination, he specifically denies that he hit a shop.
Under 166.
Yes. Yes. He has filed an affidavit in chief. It is at page 15A, 15A.
the report of the TRA General Hospital. This has not been marked exhibit though. Just marks exhibit.
Yes, exhibit 6. Part of exhibit 6.
Says, according to the patient party who was riding on a bike, accidentally to save a cycle, he hit a roadside shop and got injury on head and multiple parts of body.
My lord.
Initially, patient was brought to Calcutta hospital by local people. The patient party first saw him on hospital and referred to Arjikar.
Yes.
TRA by patient party.
Yes. Malad, that exactly is my point. I do not dispute that. But
Sir, doctor, record by you also. Sir, you should have called these people.
Milord, my specific Milord defense, my officer came before the court. And Milord, he has stated, I have read that particular line, Milord, that this is what the hospital records are specifically stating. That yes, he hit the shop, the motorcycle, Milord, on its own. There is no involvement of any other vehicle. Milord, everything, Milord, before 7.5 months, Milord, my mini truck is nowhere in the picture, whichever way your lordship looks at it. How so hard, Milord, we all try, till 7.5 months, it is absolutely in the thin air. And then, Milord, it drops in by way of this father's application, which he got information from Uttam Shah. Which Uttam Shah? The one Uttam Shah who informed the police after 3-4 days. Police did nothing after, in spite of knowing about this offending vehicle.
well, I do not know about that. I do not have any information. My humble submission only one, my lord. The 4 tests under Birender. Mr. Singh's client has satisfied none. The father, I am not disputing that document. That document I have exhibited. In that document, the father came to know about this information. The father is not the eyewitness. The eyewitness has the cross-examined. In the cross-examination, nothing adverse has come. The IO who investigated the mechanical report, the seizure, everything was there. He did not call for all those witnesses. It says mechanical report conducted, and then yes. So these questions, the owner, they did not summon the driver. The driver's details is there. The victim, the car, the offending vehicle was seized. It was released by the owner. He was there before the ACJM Barakpur. These questions they should have put to the eyewitness and the owner.
They must have asked because the application filed with PCJ was for
Further investigation, yes. And I have written this same the averments in the first reinvestigation petition. I made it before the Domdom PS as well. And it is stated in the charge sheet that one petition was filed in the Domdom PS and application for reinvestigation before the ACJM Barakpur. Both. The father made both the petitions. So, my lord, he is not the eyewitness. Even if he said that my son hit the shop, he was not there in at the time of the accident. The owner, the driver, the eyewitness. Kindly, my lord, where is the cross-examination of the eyewitness itself? They did not put the relevant question before the eyewitness after filing 170.
My lord, in criminal case, I have got no footing. I cannot enter there. Okay. As far as my lord, this is the same story is going on, my lord. The vehicle implantation absolutely clear. My lord, insurance company till my lord more than 1 year after the accident is not aware of anything. My lord, 1 year or 1.5 years after the accident, claim case is being filed. Till then, my lord, is absolute silence everywhere. My lord, the initial information, my lord, a lot of things is being said that why owner was not summoned. Owner is supposed to inform the insurance company in terms of the act itself. So lordship will put the responsibility upon the owner because the act statutorily provides, my lord, the responsibility upon the owner that immediately after the accident you inform the police and the driver as well. You inform the police, you inform the insurance company, you take the victim to the hospital. The lordship will put, my lord, at least for once in one case, my lord, put the owner to task. You did not comply the statutory provision. The statute gives me the protection, my lord. Nothing is being done. Vehicles are being implanted. Owners do not say anything because they get money, my lord. Otherwise, not out of court, which we all know otherwise. So if you indulge, if you take money, then you be responsible, and then you take the suffering also. Then make payment. If you do not comply with the statute is made for what, my lord? I don't understand. Put this question to myself.
Okay.
I'm grateful to your lordship.
Yeah, the matter will be.
Well, I have one matter with Mrs. Paul, only calculation.
This matter I will dictate after 2.
My
It
lord.
will take some time.
Lordship, lordship.
So prior to the recess, if we can finish off one matter.
সত্যনারায়ণ সাহাটা কি করে নেবেন ওটা
ওটা তো করে নাও, ছোট আছে তো করে নাও ওটা। আমি একবার দেখে নি ওটা তো আমি।
ঠিক আছে।
My lord, here just mention one matter, my lord, 96 claim cases. For the petitioner by claimant, and I'm just praying for a leave to file the paper book before the department.
So you go and file the paper book. Who is
Actually, my lord, the time limit has expired. That's why the department has said that your direction for file the paper before the department.
what is it? Where is the record? Recordটা কোথায়? You file it in the court, Chanchal.
পেপার বুক আমার কাছে আছে, মানে এখন ফাইল করানোর ডিপার্টমেন্টে কি ফাইল করবো? ওকে, I will file.
Yes. Which one is yours?
211. I have preferred the appeal, my lord, mainly. I have preferred the appeal, my lord, mainly on 4 grounds. One is income, multiplier, future prospect, interest, and fake driving license.
What is
It's an accident of 2004. Victim was a bachelor. He was aged about 28 years. Parents filed the claim case. It was alleged that he was a businessman. In the name and style of some Sohal engineering work. Tribunal took the income to be 7,000 per month in the year 2004.
any
documents?
documents?
Documents, as in, my lord, one income tax return for assessment year 2003-2004 was exhibited, but no one came to prove it. And it's a manual return because during those times, and along with it, one auditor's report is also there, but nobody, it had been marked as X for identification. It's at page 69. That is one. Multiplier, admittedly, it should be 17. 18 was adopted. And future prospect should be 40%. 50% was granted. And interest, along with simple interest, my lord, compound interest was also granted, 6%, 6%. It should be only 6% simple interest. Now, regarding this fake driving license, we have given evidence. It's at page 17. The upper division clerk from PVD Biltola, he came and proved that the driving license which was seized, it was not in the name of the offending driver. My lord?
You brought this issue before the
Yes,
tribunal?
yes.
What
We
did the
brought this
tribunal
issue.
say?
Tribunal observed. It's at the observation is at page from page 65. The observation is of the tribunal is there.
Third paragraph. Now I wish to discuss the next point of agitation which has been brought before this tribunal. They have brought one witness as DW1, namely Shubroto Paul. This particular witness works as he brought two registers and produced documents that driving license number such and such in the name of Shiv Kumar Rai, accused driver, was never issued in his name. This particular witness stated that actually the said driving license was issued in the name of Dhananjay Shukla in the non-transport category. So thereafter, at page 67, after discussing it at page 67, tribunal came to the conclusion that since the vehicle was insured with national, so we should pay.
Yes.
At page 29, my lord will see this driving license. It was seized of Shiv Kumar Rai.
Yes. Anything else?
No, these are my mainly these are my 4 points, my lord. My lord will kindly come to page 17 once. It's the evidence of DW1, that upper division. Yes, my lord. So I pray for complete exoneration, but in view of the judgments passed by Supreme Court, my lord, if I pray for pay and recovery.
My lord,
And regarding the income, since it was not proved, nobody came to prove that. It's at page,
I have seen.
my lord. So these are my only grounds.
my lord, I concede so far as the future prospect and the multiplier part is concerned, it will be 17 and 40% as per Sarla Verma. Non-pecuniary damages excess has been given, it will be 36,000. Only regarding the income, my lord, I'll not cite any documents. I'll only, my lord, kindly take you to page 67 of the judgment, how the tribunal has dealt with that
I've
income.
seen. The
The
parents
tribunal,
are aged.
yes,
They could not get somebody else.
in the year
The mother will not
2004,
be lying.
so court has, we claimed 21,000. We could not prove. Court reduced it and said 7,000 rupees. So, my lord, I am humbly praying, my lord, I do not have any cross objection, but this 7,000 has, my lord, I am praying that it should be not be interfered with, because they made an effort to prove the income tax return, chartered accountants, auditors report. They tried to file, but they could not bring. And the victim, the claimant, my lord, itself is 80 to 83 years old, my lord. Only victim, only claimant left.
Barring the income tax, that document, the trade license was also nothing. No other document was, my lord.
Yes.
Son. 13th of March 2004.
Yes.
My lord.
My lord. বেশি দিয়ে
Auditor's report.
Yes.
One. The victim based on the evidence of father of the victim.
Yes. In the claim application, I have mentioned, my lord, 1,70,000 per annum.
%50.
Future prospect.
Simple as well as compound interest. 6%. In default. Simple was granted along with that compound. Simple interest. My lord. Right. 18. 17. And general damages should have been and fake driving license.
Liability was advanced for the insurance company. Same payments from being exonerated. Thanks for identification for really that's it. As for the like however it was not possible for the prisons to Then the transaction has made a mistake.
Why, my lord?
Tribunal claimed that we claimed 7,000.
Here, this is because I that is why I had stated. Here it is necessary to mention that as mother of the victim, she herself is claiming her son's monthly income at
7,000. That's a mistake. Well, that's what I mentioned. Yes. Yes.
Father.
Yes.
My lord, my lord.
Yes, father died. Only mother is remaining.
After
Perfect. And the interest, my lord. Page 17 and the and page 47. Exhibit A by 1. DW1 is the my lord. Beltola.
that's what
Grateful, my lord. Viral. The calculation, my lord, I'll just go through it once. I'll give it here.
Ready on that. No, it is not legible. I'm having difficulty. But I'll be doing one more matter. That is item. No, I was just looking through the paper book. I was Lordship asked me, but it is non-involvement. 10 months after the accident. What will you do item 210?
ইয়েটা করে নি
204, 205 not ready.
No, no,
Hmm.
no. I saw about this. Why the number of documents are not legible? Although it is mainly on the ground of non-involvement, the accident from the date of accident, nearly 10 months after the date of accident, this complaint was lost for the first time. As far as the certified copy was, even the evidence part, is also not legible properly, so
So you need to get a copy from
Lordship.
the TCR.
absolute lordship.
Actually, my lord, we have made it from certified copy. Mr. Singh only supplied that certified copy, but
gave me the set of certified copy, but this itself,
itself is light, very light.
very.
Do we have the TCR?
Yes.
Yes,
Yes, yes.
Have you saw that?
So what do you want to do? I mean, what
What do
would
you
you
want
do? I mean, you get a certified copy from the department.
We want to take a fresh certified copy from this.
It's
Then
one point involved on your part.
mainly, yes, 1 point involved, mainly non-involvement.
So what about 2010, 210?
My lord,
2010 we will do.
we'll ready.
Both of you are
Yes,
here.
yes, yes, yes.
No, I want to dictate this matter at the end.
My lord.
Lordship.
This 188, 189. That let us clear of any.
Yes.
You have any matter? 200.
Yes.
You are there with Mr. Mondor?
He is the advocate.
Okay.
I appeal the claimant's appeal for
এই 210 এর ফাইলটা।
only two grounds, my lord. Future prospect not given, and non-pecuniary damages only 50,000 given. Injury case treated as a computed as the compensation has been computed as a death case. Personal expenses has been deducted. That should be not be there. Nothing else. And insurance company has already satisfied the award. I am here only on the ground of 15% future prospect and non-pecuniary damages. 50,000 has been awarded.
You show me the calculation.
Calculation is at page, my lord, 23. 23.
Income is all right?
Income and everything is all right.
So pain and mental agony you have been given.
Yes, 50,000, my lord. 85% amputation
What
case.
happened?
Amputation case, my lord. Kindly see page 61, 61. Item number.
Accident of which year?
Accident of
2009.
2009.
Right hand amputation.
Above
of
elbow
elbow.
amputation, right hand through upper 1/3. But I am praying
2001.
2009.
Nine.
9. Well, at 50,000 awarded something. If non-pecuniary damages only 50,000 for an amputation case, my lord will increase something on that account, my lord.
Medical expenditure. What did
I
you
have
say?
proved.
The other one?
Yes,
Future
yes. One
prospect.
future prospect not awarded. It should be 15%.
What was the age?
58. Multiplier is 9. 50 to 60, 15%.
He was working as?
As my lord, he was working under the office of the BDO Bharatpur 2 Murshidabad.
It's a government job.
Yes, 15%.
So he was 58 on
At the time of
date
accident.
accident.
Yes.
He must have retired.
Yes.
You have received the money.
Yes.
Okay. What else do you want?
Nothing else, my lord. Only that future prospect part,
Only future prospect.
my lord.
Though I would say he was continuing with his service.
My lord, that has not, I have checked that, my lord.
If he is in government service, in fifth, and on the date of pronouncement of this judgment,
My
he
lord.
must have retired.
Yes.
So where is the scope for future prospects, sir?
My lord, 50, whether or not the job was there or not, that
Whether
has, my
what
lord,
job?
kindly see the cross-examination. It is at page 12. It starts from page 12. There's no cross-examination with regard to the status of the job.
So that is
Page-
your the cross-examination?
At page 12, my lord.
He also did not say that.
He did not say that, my lord.
Then-
He said, my lord, kindly comes.
Has he
My lord,
stated
yes,
that
yes,
I have
at page 10. At page 10. At page 10, paragraph number 4, last line. Due to the accident, I lost my job.
page?
Page 10, 1010, paragraph 4, last line. At the bottom of the page. My salary was 18,444.
Did you prove his salary?
Yes, yes, yes.
Who came?
The employer, my lord, it is at page 12. The page 13, my lord. Accountant come head clerk of Bharatpur
The,
2 BDO office.
The respondents did not pose any question as to whether
No,
his
no. At page 12 is the
service
cross-examination.
came to an end or not.
May I?
Don't tell me, page 13.
Yes, page 12, they have cross-examined. I have filed this affidavit. I am no longer in service. It has been confirmed in the cross-examination.
I'm getting my pension.
Yes.
I retired from
Yes.
my
June
what
2011.
third?
My lord,
Blatant lies, my lord,
Well,
by the victim.
I am no longer in service. I
retired in
retired
June
from service.
2011.
So,
He has said that.
so retirement and losing job, do you want to say both are same?
My lord, no. My lord, I'm not saying that. At page 10, he has said that at the time of accident, I was 58 years old and I was a government employee under BDO, Bharatpur 2 OCM RLI, and I draw salary of such and such per month. Due to this accident, I lost my job. In cross-examination at page 13, he
12,
says,
12.
yes,
I have filed this affidavit in chief.
I am no
longer in
I
service.
retired from
I-
service in June 2011.
I retired from service in June 2011 and I'm getting my pension.
Yes.
So if a person loses the job, that means what? He was asked to leave the job.
My lord, regarding
Come on,
future
sir.
prospect, my lord,
Nothing doing.
it is awarded, my lord, it is awarded to compensate for the devaluation of money's worth. My lord, that is the logic which the Supreme Court has given in Sidram as well, that it is for the devaluation of money's worth. And he is, as per law, he is entitled to 15% future prospect, my lord, 50 to 60 years. My lord, Sidram judgment, my lord, I'm not carrying it right now. My lord, kindly, my lord, let me place it on Monday, my lord, kindly, please.
My lord, may I? I'll take 2 minutes of my lord's time. My lord, blatant lies being made before the court. Your lordship will, my lord, and I don't think, my lord, being so meticulous what he is not aware of page 58, 59, and 60.
No, these are my exhibited documents, my lord.
That is exactly what I say. Your documents and the way we all know that so meticulous you are. 58, my lord sees from the accident. 59, your lordship
No, he
sees.
has stated
my lord-
affidavit examination in chief was prepared by him and cross-examination was during cross-examination the deposition was by the person himself.
Your lordship,
So
my lord,
that is the
page 60.
there lies the sophistry.
No,
you
but
know?
my lord, he should be correct before your lordship.
No.
My lord, page 60, your lordship will kindly see. At the time of retirement, is my lord there at page 60?
Yes.
At the time of retirement, my lord, his gross says 21706 in the middle. 21,706 rupees. This is what his salary is. At the time of accident, my lord, this is 2 years after his accident, not when he retired. And my lord, at the time of accident, his salary was 18,000 odd.
Then-
Salary increased, got full salary, got full pension, and now, my lord, where I join issues here, my lord, his loss of income has been considered at 85% for the rest of his life, and he has, by using the multiplier, my lord, of as per the Sarla Verma, my lord, multiplier of 9, considering his age, and my lord, he has been given, my lord, this 13 lakhs rupees in
But
principle.
sir,
Lordship,
in one of the matters, actually,
my lord,
there was this huge bulk,
yes,
as you know.
yes.
I came across one judgment where similar issue was dealt with. Right there, I believe a certain percentage was.
Milord, I'll give that, Milord. This is UP State Road Transport Corporation versus Vibhor. Milord, Rajkumar Ajay Kumar is, Milord, the principal. You talk about, Milord, pecuniary loss, you talk about non-pecuniary loss. In this case, not even one single paisa pecuniary loss is there. Against that, no loss. Milord, he has got 13 lakhs rupees in principal.
Which they have paid.
Yes, of course.
They have accepted the award.
Yes. So
then,
Milord, may I, Milord, he continued without showing the relevant pages, Milord. Only the relevant questions came from your lordship and the pages were still not shown. So, Milord, when no loss is there, Milord, he got 13 lakhs. In addition to that, Milord, there are, Milord, I'm forgetting about interest, Milord, from 2019 to 2023, Milord, when the
9, as you said. 2009.
2009, yes, I'm sorry, 2009, Milord, till that, Milord, he has got more than 25, approximately 25 lakhs he has got. Amputation is there. He is only entitled for non-pecuniary. Milord, how much non-pecuniary he will get, Milord? When there is absolutely on evidence, admission on their documents, he did not lose even a single rupee. Milord, this access payment was made. My client has satisfied, Milord. Yes, this is what, Milord, is being held against me. That why did you pay? You have paid. Yes, of course I have paid. Just because I have paid, now you will come up again and you will ask for more money? No. Milord, High Court as well as Supreme Court is absolutely clear. But even if there is no cross objection, if under one particular head, the claimants, my lord is aware of that. Milord, they've got excess amount. If my lord wants to increase, Milord, 5,000, 10,000, 50,000, 1 lakh under non-pecuniary, still, Milord, they were benefited by more than 6, 7, 8, 9, 10 lakhs. Still, in excess they have got. Whichever way, Milord, the adjustment is being done. 1/3 deduction, Milord, 1/3 deduction of what? There is no loss. Milord, 85%, Milord, disability has been considered for loss of, Milord, one limb. Milord, now again taking, Milord, this judgment, Milord, functional disability has to be assessed.
Now, let us not get into that.
So, Milord, I say, Milord, why now you pay for enhancement after getting, Milord, 13 lakhs in principal with interest around 25 lakhs now. So now you since you've got that, my client was at fault that why did I pay? Why did not I come up before the High Court? So now you suffer more. Milord, this is the argument. The judgment, Milord, what my lord had asked, Milord, that was this. Milord, if there is no loss of income, future prospect will not be granted. The last one, Milord, what we had discussed, I have shown it to your lordship. Functional disability, Milord, has to become, Milord, decided by way of, Milord, the particular loss of limb. Milord, page paragraph 11. The specific question, answer to my lord's query.
No, what was his age?
58.
58.
58. So he was in service and he retired in the
Within
year
2 years.
2011.
Yes.
And he was drawing a salary of 18,000
Which,
on the date of the accident.
Yes.
yes.
And on the date of his retirement, he was drawing
21,000.
20,000
Yes,
odd.
21,000.
20,000 odd.
Yes,
There was no-
21,786.
Right.
700.
There was no loss of income
Absolutely
at
no.
that. And thereafter, he was
Getting regular pension, whatever he is entitled to.
had been drawing the pension amount.
Lordship. Still, Milord, his loss of income was considered at 85%. And then, Milord, compensation granted on that.
And satisfied.
So
Milord, this
you mean to
judgment
say-
says,
Well,
You mean
Mr.
to
Singh,
say, you mean to say they made a mistake?
yes, that's what he's saying.
well, we were just discussing this.
Okay.
Ideally, they should have preferred an.
But
Yes.
sir, today you have disappointed me.
My lord, why, my
I
lord?
asked you questions, you did not give me a proper
But
answer.
I was waiting for that reply,
My
whether he
lord,
gives or not.
these are my documents, my lord. I haven't.
You,
My lord, may I cite that case, my lord? Kindly give me 5 minutes, my lord. I'll bring that case.
anyway, you cite, but I'll dictate.
Title 2. This amount.
No, my lord. But how will we bypass Pranay Sethi?
We will, because of these judgments.
How?
Pranay Sethi, Pranay Sethi speaks about, the loss of income. There is no loss of income. It's an injury case. Pranay Sethi is specific about death case. Your Lordship will kindly, my Lord will kindly, my Lord, Pranay Sethi is about death case.
In this judgment itself,
Lordship.
if you go through this paragraph,
My Lord.
it's not there. Now, let us not go into such details and rely absolutely on this,
My Lord.
then all these will come into play.
My Lord, is still, when a person,
Let me see.
my Lord, your Lordship is taking the wholesome picture.
Mr. Singh, we
Lordship.
need to address the points that he has taken in his memo of appeal.
Lordship.
Let's not stretch it further, right? If you want to
My Lord.
rely on this judgment,
Lordship.
right? Absolutely, then you should take into account all these heads also.
My Lord.
You have not filed a cross objection.
My Lord, as a Lordship.
You go through this and then you will understand what I want to say. These heads have not been taken into consideration, right?
I'm looking into the box. Yes.
No, I'm not. Tell me that. You see?
Lordship. I've got another copy. Lordship, kindly. Yes.
So, if you come to this, the medical expenses which were granted,
Lordship.
restricted to the ones which he had incurred.
Yes.
There was nothing granted with regard to this attendant charges, special diet, after considering all these things were not there.
But my Lord, which was given, which that he was not entitled to. Your Lordship will kindly take note of that.
Now, after you have
But my Lord, I
disbursed, sir,
yes,
at this stage,
Lordship.
you cannot contradict.
No, my Lord,
or
I'm
refute
entitled
that.
for adjustment. This is what I say.
Then
My Lord,
why
I'm not
raise
asking
your
the money
cross
back.
objection?
My Lord, without, my Lord, your Lordship will kindly say, my Lord, without cross objection, my Lord, I'm not asking for refund. My Lord, I'm not asking. My Lord, in that judgment, your Lordship, my Lord, it was appeal of insurance company, State Road Transport Corporation, Supreme Court went on to the level, my Lord, and they said that yeah, you refund the money. This is what the last paragraph says. In this case, I have given in access the confession of my learned friend is I should have preferred an appeal. I did not. I'm not asking for refund, Miller, but at least I'm asking for adjustment.
This, I mean, whatever he's claiming, he's
Yes.
not getting it. Whatever he's
Milord, if
claiming,
it
he's
is not
getting it.
enhanced, Milord, if the award is not enhanced, Milord, I'm not arguing.
No, but award
Milord, I'm
will
not
be
arguing.
enhanced. Award will be enhanced because, my lord, the
Okay.
tribunal has deducted 1/3. Deduction in an injury case is not permissible, my lord. The pranayacity is very clear. We can't bypass that. I understand what Mr. Singh is saying.
On that portion, you have claimed future prospect?
My lord is not giving that.
No, because
Non-pecuniary damages, yes, non-pecuniary damages, my lord is not enhancing. I understand that.
Because they have taken
I understand, my lord.
85% of the entire
Yes,
I understand, my lord.
entire body.
Yes.
Careful to your Lordship.
Yes.
So-
my lord, at page 23, my lord will see there is a deduction towards
Because-
personal expenditure. It is one of my grounds that in a injury case, deduction is not allowed. I'm not adding the future prospect or the non-pecuniary, but deduction part has to be. Yes. Non-pecuniary damages, my lord, is not enhancing. Yeah, I understand that. I bow down, my lord. My lord. My lord. My lord. I bow down, my lord. My lord, I am only not deducting the personal.
My lord, just to give answer. My lord, tribunal considered 85% to entire body. My lord, I'm grateful to your lordship. My lord, is ideally, my lord, it should have been 30%, 40%, the loss of income. In case the maximum, it has given my lord 60%. Even after deduction of 1/3, it comes to 60%. My lord, 1/3. No, my lord, 81. My lord, what he is saying, 1/3 deduction should not have been. So, my lord, after deducting 1/3, my lord, it's a personal expenses deduction of 1/3 was wrongly done. My lord, injury case is not taken into note.
Yes.
It is not taken into note in my lord pranasati. My lord, pranasati, my lord, is not dealing with injury case. Number one, injury case is dealt with my lord Rajkumar Ajay Kumar. In injury cases, personal deductions are not to be done. Correct, absolutely right. But my lord, in that case, your lordship will kindly consider the functional disability. Then what will functional disability be? My lord, 60% in maximum in this case. My lord, after 1/3 deduction, he's getting more than 60% because 85 was total loss of total loss of my lord income was considered 85%. So, my lord, they have got without any loss of income, they have got 13 lakhs. Your lordship will say, okay, you take further. By my lord, by personal deduction.
Yes.
Lordship. Medical expenses. Or general damages, my lord.
Yes.
Whatever,
Yes.
that's lordship. My lord.
Yes.
Lord, I'm not even for one saying that your lordship will, my lord, allow 1/3 deduction. I'm, my lordship. Yes, my lord. My lord, may I indicate, my lord? My lord, pecuniary loss, non-pecuniary loss, my lord, this issue is very clear. There is no pecuniary loss. Your lordship, my lord, kindly, my lord, if there is no pecuniary loss and still he has got, my lord, 12 lakhs against pecuniary loss, how can, my lord, of any single rupee? Lordship.
Just pick 1/3 of the elbow means what? Entire hand goes.
Yes.
Right?
Yes.
So that is something. If at all, in the year 2009, according to the meters.
Absolutely correct, Lord. I agree. Yes. My lord, lordship will increase that to 2 lakh, but do not give pecuniary loss to them. My lord, my lord, your lordship, my lord knows, my lord's heart. One was not entitled for any single rupee for pecuniary loss. He has got 12 lakhs, and my lord is this gentleman for pecuniary loss. He did not suffer any. My lord is today here. My lord is dictating this judgment, my lord. A person who does not suffer any pecuniary loss, he has been granted 12 lakhs for that. They have received it. And today, my lord is saying that, okay, in addition to 12 lakh, whichever way, I'll give you more for pecuniary loss. On principle. Yes, this is what is happening. My lord, if my lord, the moment my lord takes off this 1/3, then my lord, what happens? The amount increases. In addition to 12 lakh, they are getting more. But perhaps I'm not clear to your lordship.
Where is do you have pranasati?
No, pranasati.
Or this
Raj, my lord, we can give one copy, my lord.
Calculation should be accurate. That's it. I mean,
My lord, calculate.
That's wrong. Checking it once again.
No, my lord. I'm my lord, but lordship, my lord, will be then, my lord, will bifurcate, my lord, this entitlement into pecuniary and non-pecuniary. Pecuniary, there was no loss. Non-pecuniary, they are entitled to. Against this no loss, my lord, they have already got substantial amount of 85% loss. for the rest of their life, where they were, I'm sorry, Lordship. City back in the City না রাজকুমার রাজে কুমার জোসেফ চাইছে
হ্যাঁ দিয়েছি
বলছে ওখানে খুলে দিচ্ছে Miller, on the basis of 80, I'm sorry.
Yes, at page 23. My lord is at page 23.
Huh? Miller, I was. I'm grateful to your lordship. So, Milord, that is why I say, Milord, when I'm not asking for refund, then Milord, at least no further increment or no further enhancement should be made. This is the only thing what I was saying. I'm sorry, Milord. If Milord, then if I could not express myself properly, Milord, my only submission is no enhancement should be made. He has already get too much in excess. Lordship.
That's an injury.
My lord. Lordship. I'm grateful to my lord. Lordship. Lordship.
Future
Prospect. Lordship.
Get this.
Milord, Lordship, kindly direct them to refund the excess money.
They cannot.
The appeal is as such case.
No, but
Milord,
my lord,
refund
I
the-
have one of my ground is the
Refund.
deduction towards personal expenses.
No, this
I'm,
is-
so, I'm sorry, Milord, I'm sitting now. I'm sorry.
My lord, one of my grounds is the deduction towards the personal expenses. But my lord, deduction towards personal expenses.
This is for deduction towards personal expenses.
That
Where is the issue for
in Sarala Verma,
together?
my lord,
There is no income as such,
my lord,
right?
my lord,
Pension,
my lord,
irrespective of suffering the accident.
my lord,
In any case, if the accident did not have occurred,
my lord,
the manner in which you would have received the pension, you are continuing to receive, right?
my lord.
So where is the scope of this 1/3 of such and such?
Yes, no scope.
You are not
So I should not, I should not be.
all these details now that you whatever.
One ground, my lord. This point number 2 at page 23.
So that's what I'm saying. I will send. Let's not get into this. Mr. Singh misunderstood me.
No, but I am like my lord. I am putting my case.
This, whatever you are received, whatever they have paid, be satisfied.
But my lord, this is directly in contradiction to the judgment that in an injury case, how can this deduction be allowed? And they
Then that deduction will go away, you pay them back.
they have satisfied the award. They have accepted the award, my lord. They have not even.
This, you cannot go hot and cold in the same way. If you are saying that they have already paid,
Yes, yes,
you are coming.
for enhancement. My lord, this is wrong.
You see more with something which you shouldn't have received.
But that is not before your lordship. My lord, deduction is outright illegal. My lord, I understand. No, my lord, I bow down before your lordship. My lord, kindly. My lord, how will we bypass the deduction? It is for death case. It can't be applied in an injury case. And then my award will go up to 18,36,000. My lord, it is, my lord.
Misconstrued, misinterpreted, misunderstood, granted, shall be.
My lord, kindly let me explain one thing.
Said it's not. Very first point I said that this deduction should not have been there. Yes or no?
Yes.
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 So that means what? That means you are entitled to more.
Yes.
Then judgments.
My lord will strike down the deduction part. My lord will say, I am not.
Whatever has been done has been done. Be satisfied with what you have. Read it.
My lord, one.
Huh? Milord, your lordship, instead of refunding, Milord, again, he conceded to that why did not you file your cross, otherwise we would have refunded. And now,
My lord, this.
Whatever it is, you have received the money.
Yes.
And bring them an assurance that we get it enhanced.
My lord, the thing is, my lord, let me just, my lord will pass my lord's order. I am not on that. My lord, kindly let me just hear me out once. It's a legal impossibility, my lord. Deduction in an injury case. How will my lord explain that? Well, it can't be done in my appeal.
Then, that can dictate the other judgment. Right? I mean, I don't know. This might be a divine providence. Then I came across a judgment that reading. Because in that matter,
non-involvement.
the other matter,
Yes.
the Caesar had done. Absolutely. And the Supreme Court said that the amount, compensation amount has already been received.
Yes.
But disposed of without the direction of remand.
They can do it. Under 141, they can do it, my lord. Well, it can't be because there are judgments
Let him go against my lord. Let it test my lord's order. My lord will kindly pass an order.
My lord, let me then place judgments which says if there is no cross objection, I cannot be asked to refund. There are judgments of this court. There are judgments of Supreme Court. Mr. Singh has argued that Ranjana Prakash matter. I am not disputing that. I'll accept whatever, my lord. Well, I will not get into this. My lord, no, we are not. My lord, my lord, my lord, my lord, my lord.
What you made.
My lord, my lord, my lord. My lord.
Except
many cases, my lord,
except
many
one or
cases.
two. Except
My
one or
lord,
two.
when
All,
they had-
in all
he had-
cases, I could not convince your lordship.
Where Mr. Singh had very good case, he has succeeded. My lord, absolutely. My lord,
Yes.
my lord.
Balance
Absolutely, my lord.
where the person had lost substantial amount of income, had no source of income, had no future avenue or ability to maintain himself. Things would have been absolutely different.
My lord. My lord,
But here, the tribunal itself made a mistake of deduction. You have got to even bolster that mistake which the tribunal had committed. Yes or no? You are saying that you're contradicting yourself, Mr. Mohan.
yes.
Now you have come here to say that the fraction was wrong.
No, I'm saying this deduction should not be there at all. 1/3 deduction should not be there at all.
The deduction should not be there at all. So then what about the balance?
Let,
Then that 1/3 and 2/3 entire portion goes.
yes,
Goes.
yes,
You are left with 18 or something.
yes, yes. 18,101.
Yes.
Yes,
Additional amounts
yes,
taken into the aggregate
yes, yes.
for only confined to that 18,000.
My lord, my lord, my lord, my lord. My lord, I 12 lakh 82,000, 12 lakh
Lord, he's
82,000.
only
My lord
insisting
has
that
awarded.
There is an error of calculation. He is not going into the
Yes.
principle.
Yes.
Yes, but he's not. My lord, knowingly he's not getting into that.
My lord, my lord. Kindly, kindly, my lord. 12 lakh 80,000. No, my lord, I have understood. My lord will not increase. I am satisfied with that. 12 lakh 82,000 the tribunal has awarded. I am fine, my lord. That award will remain restricted to this amount. But academically, my lord, in an injury case, if we allow the deduction, this will set a wrong precedent. It will affect other cases where injury in 1/3 will be deducted. Quantum at all.
My lord, your lordship will kindly, put in one line, my lord, that he was not entitled for any pecuniary loss. He has already been granted.
That
my lord,
would
so
be
and so.
that would be wrong, my lord.
What
That would
wrong?
be- But my lord, yes, yes,
Be against the principle.
yes. Of chronicity and salary. Yes, yes, yes.
See how the
Grateful to your lordship.
five verdicts.
But last one indulgence, my lord. Well, something on non-pecuniary damages should. Well, one ground or the other, my lord. Something.
That supersonic mimics. So by this time, first of all, I said pretty well come to this point that parents, instead of taking pushes, you should have stayed away completely.
These are my pleaded grounds, my lord.
That's what. By this time, you see, there are many people by now they don't come and beat around the bush.
No, my lord. I'm not beating around the bush. These are grounds, my lord. Well, something on the account of.
So if you had not created all these, then now he will take the advantage. You are shouting unnecessarily today. Right? He did not even understand what I was saying. That is a problem. Too many cases altogether. Effect of Mr. Omicron right to some extent. Effect of Mr. Boni to some extent. Everything getting juxtaposed. you want me to make it simpler, I can do it.
Lord
If you want your entire thing to get got into it, then it will.
Lord, your lordship will kindly dictate. Lord, your lordship will kindly
My
dictate.
lord, my lord will dictate the order.
Yes.
Like, sir, it's I tell you to go back.
Yes. Yes. Yes.
So that you know there's a triangle. The total is there, and both the
My
other
lord.
parties
My
are
lord.
there.
My lord.
So that triangle needs to be completed.
Yes. Yes. We are grateful to your lordship, my lord. No? My lord, in one case, my lord, 30 lakhs increase. In one case, 20 lakh decrease, my lord, by going back. So it had happened, my lord. Yes, what is correct, that is correct. It should be there. That is why, my lord, we always pray before your lordship. Yes.
So when I tell you go back
For a month.
for a month, you know, go and an hour.
Well, these are actually my created grounds.
It's not that you are well read. I know that. You are well read. You're conversing. It's not that you are not. Now, instead of emphasizing on those 2 points, you could have directly come to that trainer. Then he wouldn't have got that leverage to jump.
I'm not blatant lies before the court, my lord. The way this
My lord,
state.
the difference that
Today he has given me that leverage. I'm thankful to him.
So what you're telling,
well,
Yes.
well, the chance,
But he was the chance.
well, the chance was valued at 8.5 lakhs without interest.
from 1 year period.
Without chance, he got 12 lakhs. Now he is taking chance for further 8.5 lakhs.
So that will be. So for this today, probably the first time Mr.
Nice. For this scolding, of course. As my lord is thinking of increasing, that is why my lord, it didn't work properly here.
In all matters, there will be enhancement.
My lord, yes. A humane approach. My lord, yes, we see that. Yes.
When a genuine case, yes. But now when Mason comes, how do I deal with them? Also,
Yes, my lord, the human approach is there, my lord. We see that, my lord, and we don't even object to that, my lord, at times. We normally. Yes, my lord. That is why, my lord, I say that we don't object to that. No, we all are. Yes, not in genuine cases, there is no question of making any objection. Lordship. And Lord, he confessed that he wanted to continue that bolster the wrongdoing of the learned tribunal. This is what the argument is.
My lord.
And then future prospect and what
General damages.
General damages, my
else?
lord.
General damages. I will not go into
My
that
lord. My lord.
because it will be opening up Pandora's box.
It will open a can of worms, my lord. It's better not to go there.
And it will open up Pandora's box.
My
And
lord.
it will more and more intricate these.
Lordship, Lordship. Those your Lordship has to give some reasons, that why those are not being granted. Future prospect, future percent, and
Future prospect, your lordship, that judgment is already
yes, yes. Lordship, Lordship,
My lord.
Lordship.
Yes.
He was in that bus, yes. Yes.
Walking.
Lordship.
Yes.
Lordship.
Yes.
Yes. I'm obliged.
Ratan Shah.
Ratan Shah, judgment দেবেন তো দর্শক। হ্যাঁ, চান্স আর যদি আমি না পড়ে আসি ওই চান্স। Your Lordship, asked 10 times the specific question. Every time he was evading. Rather, he gave the other example that I have lost my job.
That's why I said today
Yes.
you disappointed me.
Obliged, Your Lordship.
Next.
Well, only that other matters dictation is left. my
No,
lord.
I will dictate.
এদিকে চলে আয়।
Seeking for a copy from the department.
That item.
4-5.
Yes, yes.
The ones you said the
Yes, yes,
papers
yes,
were
yes.
illegible.
Yes, yes.
Who will file for the documents?
He's always
I'll
kind
file,
to
my
me
lord.
as far as paper book is concerned. I'll leave that part to him.
So that is your understanding. At times you will say,
No, my lord,
they have filed the appeal, they will file the paper
No,
book.
no, my lord, I'd never say that because that will actually delay the matter more.
Matters are of crores and crores. Filing of paper book is of 500, 1,000, 2,000. Admittedly. But once the amount is is in crore. I am unable to do it because of lack of time, to be absolutely honest. So they do
Anyway,
it,
doesn't
they
matter.
Just
এটা একবার just একটু অর্ডারটা নিয়ে নিন।
apply করি তো, দেখে নিও।
are vacated,
Yes,
so you
yes.
file the paper book and get the money.
No, my lord,
No,
entire compensation, this appeal of insurance company, amount is deposited before my lord's offices. Principal amount, was of 6,76,351. I have deposited 9 lakhs, 5,000, 10,000, something like that. With interest, my lord.
তো যাচ্ছে দেখি কি বলে।
Lordship.
This is a matter
Looked into. Lordship. Lordship.
My lord.
Lordship.
My lord.
TR general
Yes.
Yes.
cannot discard it.
Yes. Yes. Yes.
Let me tell you,
My lord.
Victor, that we do not know
Victim.
Victor is the father. So Victor,
Yes.
he had station within
3 to 4 days.
whenever a person is admitted in a hospital. This is the first person you have been informed,
Yes.
right? So the moment police gets involved, police is the one.
Yes.
So when police was given the information, the police would have so registered a case
Yes.
and thereafter proceeded
Yes.
was not done. On the now the information given by the eyewitness to the police instantly should have been recorded in a GD. Then
Yes.
GD entry
Yes.
and GD entry has not been put.
Yes.
Now nobody ever mentioned about that GD.
Yes.
Listen,
Yes.
after that there is sufficient reason and that is acceptable as to why there was a delay in filing the complaint.
Yes. He was alive and in the hospital.
Whether his statement was recorded under section 161 of the CRPC, that is also not on record.
Yes.
Now, if you come to the charge sheet,
Yes.
charge sheet is that
26. 26.
of June 2018, the complainant Niranjan Shah filed a petition with affidavit before learned ACJ, Barrackpur Court, prayer for further investigation.
Yes.
He mentioned in the affidavit that he got the information from about the offending vehicle from Achi Shah and Uttam Guha.
Yes.
Now Uttam Guha comes to the court and says he doesn't know them.
Yes. 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 He says that I do not know the victim as well as his father. Yes.
And stated that the number of the offending vehicle is such and such. The complainant also submitted a petition before the government case in which mentioned the offense. Such and such I collected owner particulars detail of such and such. So now there is a gap. Being a driver of a cab, he was moving through. There was all of a sudden he saw a light. In that light, he could see the number of the vehicle. Right?
My lord.
He went to the police station. He said after 3-4 days. So why after 3-4 days? What prevented him No one knows.
Yes. Not even asked. Yes. Yes. Yes.
Secondly, from where, after 7 months, the family of the victim got hold of the Suktam Guru and was watching Shah.
Yes.
And was watching Shah. Who filed the affidavit?
No, they did not file. Well, the victim's father filed. They got the information from these people. Yes. Yes.
They went and filed the
Affidavit before the SEJM and one petition before the police station. Yes.
Now, this question was not put to the
Eyewitness.
witness.
Yes.
Before that.
Yes.
And after 7.5 months, how come you came in contact with them?
Yes. Yes. This question was not put. Yes. Yes.
Facilitator.
Yes. Yes.
That I have come to know about this incident. I go and inform the police station of the number. Police sits tight.
Yes.
Doesn't even make a GDH.
Malad.
Thereafter, as far as the victim's family is concerned, it's reasonable. They were occupied with the people of the victim. Of course, at that point of time, they could not doing.
Malad.
But the medical reports say that in the initial stage, the victim was recuperated.
Yes. Yes.
Right?
Yes.
The TCR, the marks said he was
Yes.
you will see that he was responding.
Yes.
His pupils were becoming
Yes.
visible.
Yes.
Is there in the
Yes. In the documents, yes. 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 Yes.
So whether in his consciousness or in his semi-consciousness, the statement was recorded or not, we don't.
No, not recorded, my lord. Yes.
We don't.
Yes.
Not here.
We
Asked.
ask questions or his statements were recorded at
Yes. 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 Yes.
That is okay. Now, in the charge sheet, police nowhere stated that this Uttam Guru had earlier informed us.
It has not been mentioned. Yes. It has not been mentioned. Yes.
Or there had been a GDHP at least.
Yes. No. No.
If you go, this is a normal practice.
No.
All of you know better
Yes.
that if there is an incident, when you go to the police station, police records it. It's not that, I have witnessed an accident, I have come to inform you, blah, 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 I leave. It's not that you are not friendly with the person. That person
Yes.
go and inform and then leave.
Yes.
Right? So that is missing. That is the first aspect where the evidence of eyewitness becomes a bit unreliable. Secondly, he says, I don't know them.
Yes.
Though a question was not put to him, then if you didn't know them, how come you get in touch with them so that your names are mentioned in the affidavit before the ACJ seeking for further investigation after 7.5 months?
Yes.
You are not known to them.
Yes.
So if you are not known to them, how come you get in touch with them? You're an absolute stranger.
Yes.
What you could have done, you could have advised gone to the police station to inquire.
Yes.
If at all you had that inclination to, or else you had your personal interest, that is something
Different.
which is practical.
Yes.
Was not there. Mentioned also nowhere.
Nowhere.
Now it was the incumbent duty of the police after 54 days,
Yes.
when the complaint was first lodged, to investigate,
Yes.
it was not.
Yes.
Police, in a way, had the prior information.
Yes.
Police had the prior information. If you rely on the evidence of the
Eyewitness.
then what was given to it.
Yes.
Driver, I was driving in the light. I saw the number.
Yes.
So you saw the number. It's not that you memorize the number for a continuous period of 3 or 4 days and thereafter forgot.
Yes.
You must have written it somewhere, you must have done something. That is how you went and reported that to the police station.
My lord.
But that is not mentioned.
Yes.
Right?
Yes.
And Crown was informed earlier, should have acted on it.
Yes.
Police nowhere in the charge sheet mentions that.
Yes.
Says on the application before the learned ACJ for further investigation based on the versions of these two people, they continued with the investigation and thereafter the legal consequence.
Yes. Yes.
Now, we have a second version
My lord.
in the form of the documents marked as X6,
My lord.
where it says that was driving the motorbike
He hit a roadside shop.
to save a cycle, and then he got that
Hit a roadside shop.
to the roadside.
Yes.
Entire gamut of evidence is something which slackens the reliability
Of the eyewitness.
the eyewitness, because the eyewitness solicitor has said, nonetheless, no plausible question was put to the eyewitness
Yes.
to test his veracity,
Yes.
to confirm him.
Yes.
That was not there.
Yes.
Anyway, let not even comment on the capacity of the ones who appear. This was not.
Yes. Yes.
So now, under section 166 of the APA, the rationale.
Yes. Yes.
So, on the basis of this, just a single line you have said. Of course, there is a lapse in part.
Insurance company.
Insurance company also not to confront him and contradict him on these grounds.
Yes.
There was the lack. There has been a lapse on the part of the insurance company to do it.
Yes.
It has not been. But since that document has already been marked as Exhibit 6, prior to that, have checked.
Yes. 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 Yes.
RTA hit the shop. There also was not mentioned whosoever must have taken that person
Yes.
from the spot of the accident to the
Hospital.
hospital
Yes.
must have been aware
What has actually happened?
what has actually happened.
Yes.
Nowhere if there is a mentioning of the shop and his mobile, right? There should have been a mention that he was hit by a motorcycle or
Good. Yes, yes, yes. Yes.
himself or herself whatsoever,
Yes.
not the number
Yes.
of the vehicle.
Yes.
But
But some indication should have been there. Yes. Yes.
some indication should have been there, which is not there,
My lord.
which is not.
Yes.
So now tell me, this is my understanding. This is what I would 10-15 minutes
Not sure.
of the
Yes.
records as well as the evidence.
Yes.
Now, based on this, the entire evidence of eyewitness becomes absolutely indisputable.
My lord.
Now you can say that there is a difference between the trial in a criminal case and the
Claim case.
Trial
evidence
in a motor vehicles act. Yes.
But, of course, charge sheet is not a substantive piece of
Evidence.
Yes.
It's not.
Yes.
But primary facts, it's not a substantive piece. So
Yes.
the primary facts are gathered from the charge sheet itself.
Yes. Yes. Yes.
So in the charge sheet, if you do not find any substance
Yes.
to base your foundation, then what are you doing? In any case, it's not because in a criminal trial you have to create that chain with linkages to prove the circumstantial evidence.
My lord.
But the truthfulness of the eyewitness has to be assessed. Now here, the deposition of the eyewitness itself becomes unclear. He says, I don't know them. Knowing somebody, being acquainted with somebody, having a relationship with somebody, these are three distinct situations.
Yes.
Once you know a person, then you get acquainted and then you proceed further. Here, there is no knowledge, we don't even know each other. So, from where do you come into the picture? Your role in the initial stage to have gone and informed.
And I came to know from the father that the victim has died. He has said that I came to know from the father that the victim has died. My lord, if I may ask, my lord, what does my lord intend to do?
Yes. Sorry, allow.
Allow a minute, allow the appeal.
One thing, good rest. It should be the other way around.
My lord, if my lord decides,
This friends, with a boy of 21 years. That's what I said. But this escape route, sir, and this cannot be.
my lord,
Boy of 21 in front of a bar. What could have been the situation?
my lord, if I may, my lord, there are 3-4 judgments with regard to implantation of vehicles. Mita Samanto of our High Court, Anjali Mondal of our High Court.
I mean, the one that I was going through any where Mita Samanto was not considered by Supreme Court.
My lord, our High Court in at least 10 judgments has considered Mita Samanto, discarded that on the basis of eyewitnesses, my lord, misstatement or my lord in cross-examination and held that vehicle not involved. I can provide those, my lord.
My lord,
Considering Mita Samanto, not, I'm sorry. Yes.
if I may complete, my lord, there are 3-4 judgments basically, my lord. Mita Samanto, Anjali Mondal. I understand, my lord.
Says it this by virtue of my bit of experience in the criminal cases and all. I try to balance it off. But we cannot be so precise. We cannot see these cases with such precision as we do in the criminal case. Right? But when there is a blatant
Gap.
inconsistency, right? How can you gauge that? I'm asking you.
My lord, no, my lord, certainly not.
Sake of discussion, absolutely. If my eyes did not fall on that document, which none of you, indicated.
The medical document. That is actually, my lord, that is not part of the paper book. That is there in the TCR. That is not part of the paper book.
I find people very cleverly, I said, or rather shrewdly, I know, using the
Yes, yes, it is. It is. Yes, yes, yes. Shrewdly, my lord. That is the appropriate term. Shrewdly.
kind of they can deliberately they don't make a part of the paper book. These documents. Now, did you mention neither Mr. Singh mentioned about it, nor you mentioned about this exhibit 2, right? Exhibit 2, this small paper on the reverse has been mentioned.
Yes, yes.
Right? This, yeah. Join the Chakraborty. And if I demand to get that hold of that joint
You will never.
of any you, because
No.
you have the charge sheet, the glaring in front of you.
My lord, may I?
This one. Now you have made, this has been made marked as an exhibit. That is exhibit 6. Yes. Says so. Yes. Very elaborately it has been mentioned. Mr. Singh saw the first page. He didn't see the second page.
My lord,
has.
Singh saw the first page where it says, according to patient party, riding a motorbike is function. But on the very next page has been elaborately described. What it says, according to the patient party, he was riding on a bike, accidentally to save a cycle. He hit an outside shop and got injury on head and multiple parts of the body. Initially, patient was brought to Sagar Datta hospital by local people, and patient party first saw him at the hospital.
Yes.
Then referred to TRA. So at that point of time, sir, they were not in a position to fabricate.
Yes.
Initial stance.
Yes.
That time you people are anxious, you're agonized, you're traumatized, your mental faculty will not work in other directions.
Yes.
Right?
Yes.
So that time, initially, what was the
actual
state of affairs? You have just mentioned.
narrated.
Yes.
Right? Later on, you developed. This is now see how things
Developed.
now. Okay, history noted. Patient C, history noted. RTA with head injury and other facial soft tissue injuries. Now he was given dal, pulses, that had seen. BP became normal, its CO2 temperature became normal.
My lord.
So critical, he could, his pulse and all were normal, pupils dilated.
May I say something, my lord? My lord, if the case diary is called for, instead of dismissing the matter, my lord, kindly call for the case diary, because from that, if this dispute, if this confusion is there in my lord's mind, from the case diary we can find out what happened to that case, to the driver and the owner. The owner must have taken the vehicle, but the driver, what has happened to him? Whether he was convicted or whether he did not appear, still the matter is kindly. Yes. Yes. Yes.
Criminal case.
Yes.
Yes, yes.
Exonerate.
Yes. Yes. Yes.
Company, yes.
Paying. Yes.
Compensation. Yes.
Now,
Very
my
many
lord,
cases, my
my
lord. Very
lord,
many.
if we find,
Yes, 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 yes.
yes,
Yes.
my lord, if we find that he has admitted to causing the accident, from there, if he, no, my lord, yes, no, not rash and negligent. No, he won't say that. But if he admits to causing the accident, then the problem is solved, my lord. Kindly give that opportunity. My lord, kindly see the record once. I'm only asking for that much. Kindly let it be. If he
chances with taken, my lord. My lord has
no, my lord, I want
my lord has my lord
my
made
lord
up my lord's
call for
mind,
the
my lord.
record once and see if he has done. My lord will pass the order. My lord has already decided, so I don't have. I completely bow down, my lord. I'm not standing in the way. I'm only saying, my lord, kindly call for the records once to see if the driver, if the case diary can be called for once, because that from that it can be cleared what is written in the petition, which the father has also said. That will also be clarified. The father says, I came to know from Ujjwal Guho and the case diary, what happened to the driver who we allege that the accident was caused by him. Kindly, my lord, after that, any day, your lordship will pass the order. Because in any case, I might lose. So, my lord, only this much. And then, my lord, only as a last wish. As a last wish. Yes, my lord, kindly, my lord. My lord, to be very honest, just because it's a 21-year-old boy.
Had it been, my lord,
that.
my lord, in which
Yes. 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 My lord. No. Absolutely. Well, today, just in the afternoon, one notification has been published in the Calcutta High Court's website. 14 crore rupees is lying in tribunals not claimed. I was showing Mr. Singh that notification.
Shall I give the reason why not claimed? Because the settlement not reached.
So more than that is different, my lord. But my lord, let.
Yes. Jayanta Banerjee.
Jayanta Banerjee.
Yes.
In a matter which had filed in 2020. So I asked him, do you have any other matter? He said, no, going in the list. Then Mrs. Singh said, you only have 4-5 matters. Then he said, no, 30 to 40 matters.
আরে অনেক মামলা আছে 100 মামলা আছে
What is the urgency in this matter and why you are keeping the other matters pending and preferring an application?
Oh, the list is some other dates can be given. What is this?
Right.
He didn't even understand the purport of what I said.
Lord, I tried to explain him in vernacular, my lord. He said, না দাদা তুমি চুপ করো আমাকে বলতে দাও সব বলতে হবে I said, okay, then you বলতে হবে তো বলো
My lord,
Yes.
As long as I'm there, as much as I can, same thing, sir, I did with the criminal.
Yes.
Also, I tried to. My staff there, people don't draft my name judge. Read or the ones who do, their opinion is, God knows how many people must be addressing you from where, because they have been suffering for 50 years, 40 years, 50 years with their criminal
Criminal matters being pending, lordship. Yes.
Getting disposed of. Yes. My lord, we'll dismiss the matter.
If any of his non-involvement.
Yes, my lord, I have not been able to. And in each one is, my lord, a definite case of non-involvement. Each one is.
My lord, will if my lord feels so, my lord will pass the order, but my lord once will call for the record once.
My lord, there's another part of very good education, my lord. What we have learned, my lord, the day the court is against you, somehow try to get the matter urgent for that day. my
Pick
lord.
the matter, my lord, next week. I know, my lord, if
Another chance.
my lord, fix it next week, my lord. Any day. Dom PS. It won't take much time, my lord. My lord, it is. Yes.
Without asking the state. They will get hold of somebody from the state.
My lord, my lord.
Dum case diary, my lord, 18.
FIR number.
7, my lord, page 20. After 1 o'clock, my lord, perhaps all courts, my lord, they have
It's
finished up
empty.
their
The entire court is
every
empty.
entire court is empty. My lord. Yes. Yes. It was required. My lord, otherwise, it would have eaten the time on the other day. My lord. Yes. In the morning also, my lord. Yes, my lord. Yes, and he took, my lord, and he could make his submissions, my lord, today. He was relaxed. Yes.
And my lord, previously